had 3 courtrooms and I only have 2, but you want to say.
Who lost out? He'll survive. Who's going in there? He's going to hear about that one. Huh, okay. So you are stuck here plus, oh, you're good.
Yeah.
That's a good draw, my friend. I don't know who you paid.
We're happy.
Yep.
Yes.
Okay. It's all good. Hello? So, are you here for Mr. Stokes?
Yes.
Let's do that, because we don't have prosecutors yet for our sentencing. So if you're good to go and he's good to go.
I think it can be brought out. I was filling out the information for the family first to get to.
Okay, if you need a little more time, that's fine, but I guess you guys could do it right there. I'd like to get started on something, as long as I'm not rushing you.
No, you're
Okay.
This is my own habit today.
All right, then your weekend starts. Okay. Don't, but I'm all right with that.
For both.
Yeah. I definitely don't need one for Tuitt, or just for this, but Ms. Simpson can help out. All right, Ms. Rivers, good morning. Are you ready to go?
Good morning, Judge. Yes, I'm ready.
Excellent. Then let's get started. This is 25 SC 006-176. It's State versus Ronte Stokes. Good morning, Mr. Stokes.
Good morning.
Mr. Stokes is here with his lawyer, Ms. Baker.
Yes, Rakaya Baker, REKIYAH.
All right. Ms. Baker is here on behalf of Mr. Stokes, and we have Ms. Willingham, who I will add, and we will add that. There we go. We've got everyone we need so that Ms. Rivers can see people. Mr. Stokes, I am told that you are prepared to enter a plea. I think the charges are being reduced to misdemeanors, but I'm going to let the lawyers tell me that. That's what I heard yesterday. Whatever's happening, whatever it is Ms. Baker's told you happening, are you ready to go forward?
Yes, sir.
Okay. Ms. Willingham's going to put you under oath in just a moment and ask you a bunch of questions about your rights and about this case. You'll need to answer her questions truthfully and completely. I need you, along with doing that, to let me know if at any point you've got a question, because we're talking about something that you don't understand, or wait a minute, that's not what Ms. Baker told me. If you ever feel that, stop us so that I can explain or Ms. Baker can explain, okay?
Yes, sir.
All right, that's how it'll work. When you are ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Ronte Stokes.
Can you, Ms. Baker, move the microphone a little
Yes.
towards Mr. Stokes? He is soft-spoken. I need to make sure our court reporter can hear him.
Ronte Stokes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
27. I graduated high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need any more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Have you reviewed the indictment in this case?
Yes.
Do you waive formal reading of the indictment?
Yes, we do.
Has your client been arrested on these charges?
Yes, he has.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
No, ADA, we do not.
And Mr. Stokes, do you understand you are entering a guilty plea to the following offenses? Count 1 is being reduced to simple battery family violence with a sentence of 12 months probation. Count 2 is being reduced to criminal trespass with a sentence of 12 months probation to be consecutive to count 1. And count 3 will remain as charged, which is cruelty to children in the 3rd degree, and that will be 12 months probation to run consecutive to count 2. The special conditions would be no violent contact, complete family violence intervention program, complete families first, and complete 30 hours of community service, and have no weapons. Is this what was explained to you by your attorney?
Yes, ma'am. And ADA, I would like to add that we can't terminate once he completes the conditions.
Yes.
Terminate or suspend? I'm good with
No,
either.
no,
I
no.
just want to know.
No, the recommendation would be terminate probation. It's a total of 36 months, Your Honor.
It is.
And it's for the purpose of Families First and Family Violence Intervention Program to ensure that there's time to complete both.
Got it.
Are you aware that the court does not have to accept that recommendation, and the court can sentence you to the maximum sentence on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if you do not accept the court sentence, you may withdraw your plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you further understand, because this is a family violence conviction, if you are found in possession of a firearm, you could be charged federally?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you may waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead in indictment 25 SC 006176?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the state would expect to show that on July 27, 2025, officers responded to 4712 Flat Shoals Road, Union City, Georgia, in Fulton County. And upon arrival, they spoke with the victim, identified as Zandria Barnes, who stated that while changing her 2-year-old child, ZS, the child's father, Ronte Stokes, entered the room and initiated an argument. Barnes reported that Stokes placed his hand around her neck, choking her until she could not breathe. She stated she struck him in self-defense to free herself. Your Honor, since the filing of the charges and the indictment, the state has spoken with the victim several times, and each time she has maintained that she did not, that her breathing was not restricted. She doesn't deny that the defendant choked her, but the charge in the indictment is aggravated strangulation. And if she's unable to identified that her breathing was restricted, we would be able to prove the simple battery, as there were also no visible injuries on her based on this incident. So I have had an opportunity to speak with her, and she is okay with the misdemeanor probation. She does agree that she thinks the parties can both benefit from doing the Families First program, and she believes the defendant can benefit from the family violence intervention program separately.
Okay. Is there overlap between FVIP and Families First? Let me ask it differently. Are they sufficiently distinct that
Yes.
it makes sense to press Mr. Stokes to do both?
Yes, so the Families First is actually a total package in terms of the family. It will actually include counseling sessions that include both the defendant
Yes.
and the victim.
Okay.
To allow them to learn healthy co-parenting together. As your honor knows, family intervention program would be solely for the defendant.
Just Mr. Stokes.
So as we know, the victim and the defendant in this case plan to stay together. They have a child together. We believe that it would be beneficial to do both of them.
So ZS that has Mr. Stokes' last name. So
Yes.
that is their child.
Yes.
Got it. Okay. And Ms. Barnes is aware of this and is okay with it. Even the fact that one of Mr. Stokes' probation requirements involves her participation.
Yes, your honor.
Okay. We don't have pretrial services this morning. This was sort of a surprise calendar. Do you have any information about Mr. Stokes' criminal history, at least the Georgia side of it?
Yes, Judge, I'm sorry. 1 second. Let me go back.
And while you're looking into that, Ms. Simpson, good morning. Hopefully Ms. Simpson can hop on in a second.
And your honor, the defendant has one prior offense that he received first offender for. It was a theft by receiving. That was in 2021. There is a willful obstruction also that's from 2020, but he pled nolo on that. And then this charge.
Okay. And the theft by receiving was felony theft by receiving, but it was first offender.
Yes.
Okay. I think I follow all that. Ms. Baker, what do you want to share with me about this?
I think nothing further as far as the facts, Your Honor. I do agree that my client and the victim would benefit from the Families First counseling. I know they do have, a relationship, ups and downs everybody goes through, but I think he has learned his lesson from this incident. He is sympathetic, and he has, he will apologize to Ms. Barnes, I believe her name is.
Yep.
But we just ask that you accept this recommendation.
Mr. Stokes, how long have you and Ms. Barnes known each other?
About 5 or 6 years.
So it's not a brand new situation. How many kids do you have?
I have 3.
You have 3. How many with Ms. Barnes?
1,
And that is the little kid who was being changed when this happened. How old is that kid?
2,
2. Okay. And your other kids are older or younger?
older.
Are they in the Atlanta area?
Yes, sir.
Okay. Are you an active part of their lives?
Yes.
Great. And Ms. Barnes is okay with the fact that you're interacting with other moms, things like that? Or is that a source of friction?
No. We okay.
You're good with that? Okay, good. What was the beef in July? What were you guys disagreeing about?
Your Honor, would you like to ask him, or would you?
Well, I'm asking him. I'd like to hear his perspective on it.
Okay.
But if you think that's a bad idea for him to say it, I
I
don't.
don't think it's a bad idea. He can, but it's simply, he went out with his homeboys that night. He came back in, took a shower, and was headed back out. And it's
Okay,
fine.
so it was he's dropping in, she's taking care of this kid,
Yeah,
and
so
you're
it's essentially.
having a
running
great
his
life. Why
home.
don't you go drink, hang with these guys, you come in, clean up, and leave again? How about you help out? How about you play dad?
Yeah,
Yes, sir.
so
Okay.
that's what it was about.
Got it. Do you have questions about anything?
No, sir.
All right. Well, Mr. Stokes, I find there's a factual basis for your plea to these 3 misdemeanors. I also find that your plea is knowing and voluntary. Voluntary means no one's forced you to enter this plea. And knowing means, with the help of your lawyer, Ms. Baker, you understand all the things we've been talking about. Fair statement?
Yes, sir.
All right. Ms. Baker, can someone in my office electronically sign your name to the indictment?
Yes, they can.
Ms. Willingham?
Yes, Your Honor.
And Mr. Stokes, can we electronically put your name on there indicating your guilty plea to the 3 misdemeanors?
Yes, sir.
We'll do that. I will follow the negotiated resolution. It'll be a slight twist. It's not going to be anything that changes much for you. Count 1, which has been reduced to family violence battery, is going to be 12 months to serve 1 month with a balance on probation. But you've served 32 days. You've done that month. But I want the sentence to reflect that there was jail time in connection with what you did. So 12 months to serve 1 month, balance probated. Count 2, which has been reduced to criminal trespass, is 12 months probated consecutive. And count 3 was always a misdemeanor. That stays a misdemeanor. It's 12 months probation consecutive to count 2. So it's actually a total of 35 months of probation and 1 month custody. Special condition of probation number 1, no violent contact with Ms. Barnes. You guys are going to be around each other. When you get out, do you intend to live with her?
Yes, sir.
Is that the address, Flat Shoals?
Yes, sir.
Okay. Does Ms. Barnes work?
Yes.
What does she do?
She work at the hospital.
What hospital?
Kaiser.
Okay. And do you work?
Yes, sir.
What do you do?
I'm a tech at Turf Pride.
A tech at what?
Turf Pride.
Oh, Turf Pride.
Yes, sir.
Okay.
Lawn service.
Does that mean you mow lawns or you fix the machines that mow the
I
lawns?
spray chemicals on the lawn.
Oof. All right. Is that why you're wearing a mask? All right. Second special condition of probation is that you enter into and complete the family violence intervention program. And so you're not misled. It's actually a bunch of classes. They're one at a time. They're not all at once, but it's not just 1 week. It's a series of weeks. And you need to enroll and provide proof of enrollment within the first 3 months of probation. So you're not going to goof around, hey, I have 35 months of probation. I'll get started in 2 years. Within the first 3 months, you'll be able to show probation. I'm in the FVIP on Jones Street or wherever it is. And they'll help you find one of those programs. Third special condition is that you complete the Family First program. How does he's in it? He's been accepted?
They've already given me the paperwork and I'm going to walk it over to the person in our office who is over it, and then they will get in touch to schedule.
Okay, so they'll make sure he's doing it.
Yes.
All right, Families First is more proactive. They're going to tell you where to be and when. The FVIP, you've got to get it started. But once you get it started, it's going to be, I'm making it up, every Wednesday or whenever it is, you will be doing that. You'll need to do 30 hours of community service. You need to do those within the first 11 months of probation. So as part of count 1. And your misdemeanor probation can be terminated upon proof of completion of the Family Violence Intervention Program and successful completion of Families First.
Yes, sir.
Okay? Any questions about any of that?
No, sir.
Ms. Simpson, good morning.
Good morning, Judge.
Is Mr. Stokes on probation anywhere?
He is not, Judge. He completed his first offender, March of 2021.
Okay, thank you.
No problem.
In terms of reporting to misdemeanor probation, Ms. Baker's going to tell you how to do that. She'll get the information from misdemeanor probation. That's not, Ms. Stokes does felony probation. Ms. Simpson does felony probation. So Ms. Baker's going to let you know where you need to, if you need to report, it's actually right across the street, but it may be that they just need to talk to you on the phone, whatever it is. But obviously don't goof around with them, because if they can't find you, then they send me a warrant and we start this conversation all over again. Okay?
Yes, sir.
All right. Ms. Baker, anything else on behalf of Mr. Stokes?
Nothing further from the defense.
Okay. Anything else from you, Ms. Willingham?
Nothing further.
Okay. Well, thank you all. That's it. Can you figure out where Mr. Abadi is?
I will.
Thank you.
And he said he was coming from someone will be here in about
All
10
right.
minutes.
How long ago did he say that? 20 minutes ago? 3 minutes ago. All right. Anyone from Major Case?
Okay.
Thank you.
Your Honor, that concludes my business for today. May I be excused?
Enjoy your weekend.
Thank you. Have a good one.
Good morning, Ms. Fagan.
Good morning. How are
It's Friday.
you? Good. Good.
Okay, that's good. She can just sit and eat.
Judge, I apologize for my delay. I was in an impromptu staff meeting this morning.
That's all right. We didn't have pretrial services, so I was just trying to get a little info on Mr. Stokes, but we're good.
Thank you, Judge.
Ms. Willingham's right there.
Thank you. And tell her thank you.
Okay, I'm confused what they didn't understand about 9 a.m., but.
But I'll do both. That's okay. I don't know it's about now, but I'll still do both.
Is that count? I think you sent me the count.
I did. I went back and I just sent this code section.
Okay. Thank you.
There's a.
Oh, okay. Here you go.
Oh, yeah.
So we're going to start a little late. We have to do a sentencing from a trial that ended late yesterday, but we need a prosecutor here for that. Ms. Fagan, I'm not seeing family members here despite you saying we needed to not sentence yesterday because we needed family members.
Well, the one family member that I'd like to speak is outside in the hallway.
Okay. So they're here, I'm just not seeing them yet.
Yeah, I can tell they're coming. I asked if they were having, I don't know where anyone is.
Okay, everyone who wants to be here should come on in.
I just asked.
Okay.
So.
Everything's not. That's why they call it coffee county.
I just want to apologize if I seem lost this morning. This is my first year by myself.
Oh, really?
Yeah. The training.
Okay, so you're sort of sorting things out. Is this one where it's digital takedown or are you an actual stenographer?
It's a digital takedown.
Great.
I'm set up hardware wise. It was just like, you had systems beforehand, so I thought I was in the wrong area.
Yeah, right. No, someone said, hey, there's a court reporter here. I'm like, yes, probably for the civil thing, because Ms. Rivers, my court reporter, is doing this virtually. She can see and hear what's going on in here. And I was like, well, is she going to need to move? No, we don't need to move. She's in another city. So you're good.
Beautiful.
I'm glad you're there.
I know, I'm not, it's a good practice for her.
That's right. What was the case
Murder? Not a easement situation.
That's riveting. We were in Coffee County last week trying a chicken house. They don't want our chicken house.
That's funny.
I'm glad we got it.
Do you just stay down there for something like that, or each day you drove? That's a trek.
It's 4 hours.
Yeah.
In this Point Nemo of Georgia, there is no civilization. And if you're the farthest point from a vegetable.
Apparently a lot of chicken.
There is a lot of chickens,
Chickens,
but these chickens are not welcome.
Nor are our Vietnamese clients. So
Mm.
it was more of that.
Yeah.
The local press was great. I hear dogs and cats. It was great.
Ms. Fagan, you can move on up. As soon as we get a prosecutor walk through that door, we're going to bring Mr. Tuitt out. All right, let's get Mr. Tuitt.
You want to
You can start at the table, and it may be that Deputy Gordon wants you all to stay at the table.
Okay.
He's one of them.
I'm going to turn them on now. I hadn't thought we were going to need them.
This is baby.
Could you call?
Yeah, she's there.
Can you call back?
All right, Ms. Rivers, are you ready?
Yes, I am.
Great. Let's get back on the record in State versus Tuitt then. This is 22 SC 185328. It is Friday, October 10th. And we have Mr. Tuitt here in court with his lawyer, Ms. Fagan. We have a prosecutor, one of the two on the case, Ms. Jones-Connor, and we also have a guilty verdict. Yesterday, a jury found Mr. Tuitt guilty of murder, 3 counts of felony murder, aggravated assault, and 3 associated firearms offenses. It is time for sentencing, and we will proceed with that. I'd like to hear from the state as to their recommendation, if there are any victim impact statements, and how they think merger works with these various counts.
Thank you, Your Honor. And Your Honor, would you like me to remain seated or at the podium?
Wherever you'd like to be, as long as you're near a microphone, Ms. Rivers will be happy.
All right. So, Your Honor, just following up, it is correct that Mr. Tuitt was found guilty by a jury yesterday afternoon, finding him guilty of all charges in the indictment, 8 counts. There was a recidivist notice previously filed in this case. 2 of those convictions have been tendered as part of the state's main record.
So let's talk about the recidivist notice. I didn't bring it out here, so I'm going to find it in the docket. My recollection first of all, it was filed by Mike Carlson, so it was way back when. And it didn't include either of the convictions that were in the indictment. And so I don't know that Mr. Tuitt was on notice for recidivist purposes of those. He certainly knew about these other convictions because they were named in the indictment, but we need to be thoughtful about how we navigate the recidivist piece. I'm gonna pull the notice up.
Yes, Your Honor, and before, I noted the same thing from the record, so we do have a certified copy of all convictions. Mr. Tuitt carrying, I believe a total close to 12.
Okay, right, but he may have 1,000 convictions. My understanding of the recidivist notice is you must list the convictions upon which you're gonna rely. You can't just say, oh, and there may be others.
Yes, Your Honor. So,
Okay.
to clarify, what the state is saying is the ones contained within the filed recidivist notice, we do have a separate certified copy that we will tender before the state concludes its portion of the sentencing.
Okay, that notice filed in July of 2024 lists 3 convictions, all from Fulton, all 12 SC cases, 2 robberies and 1 terroristic threats.
Yes, sir.
Okay, so do you agree that that's the sum and substance of what you can rely on for recidivist purposes?
For recidivist purposes,
Okay.
yes, sir.
But it happens to be 3, which is the magic number to make Mr. Tuitt an A and C recidivist.
Yes, Your Honor.
Okay.
And so in regards to taking note of that, and again, we will tender all 3 before we conclude with the state's
Okay.
portion of sentencing. But in regards to that, the recommendation from the state would be as to count 1, murder, life without the possibility of parole. Felony murder in counts 2, 3, and 4 would vacate by operation of law. Count 5, aggravated assault, would merge into count 1. Count 6, possession of a firearm during commission of a felony, would merge into count 8. Count 7, possession of a firearm by a convicted felon, would merge into count 8. And then count 8, which is use of a firearm by a convicted felon, we would recommend a sentence of 15 years to serve consecutive to count 1.
Is count 8, is that statute one that is a mandatory consecutive, or you are merely recommending that it be consecutive?
A mandatory consecutive, Your Honor.
Okay. And while you're recommending life without parole, my understanding, assuming you've got 3 certified copies, is that it's not only a recommendation, but it's the sentence that applies given Mr. Tuitt's recidivist status.
Yes, Your Honor.
Okay.
That as well. Your Honor, before the state continues on, we would ask, you have seen many members of Mr. Quatavius Wright's family present during the course of this trial, during the course of the case. We would like to begin with a victim impact statement from his sister, who is present today.
Okay. We're hearing something different. I'm happy to hear from whomever. It could be sister or mom or aunt. We just need to do one at a time.
And we were asking that to do both, and we'll follow their order.
Okay, great. And what I'll ask you to do is to come sit in the seat that just had, okay, right there. Great. So ma'am, if you could please introduce yourself so the court reporter can reflect who you are, and then I'd like you to share with me anything and everything about Mr. Wright, your connection to him, the impact that his murder has had on you and your family's life.
Thank you, Judge Ronnie. Good morning, of course. My name is Carlethia Wright. I'm the mother of Quintavious Wright, Quintavious Keywan Wright. I didn't know I was going to do my impact this morning. I thought my uncle would be here. Apparently, he's running late. So bear with me. I'm still grieving. I want to say that Quintavious Wright, Keywan Wright, is my first son.
Hold on one sec. Sorry about that. We'll try to make that not happen again. I don't know what that was. Keep going.
Quintavious is my first son. So having him out of having 3 kids, 3 girls first, was not just a blessing. It was 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 it was amazing for me to know that because I thought I couldn't have a boy. So when he came in the world as my protector because he didn't cause me no problem when he was little. Took over his sister and them as being a little big brother. So that's what they call him. He played basketball. He was a sports fanatic, so he played basketball, sports. Also attended Atlanta Area Tech in college. Was getting ready to go back to school to get his auto mechanic license. Quintay was very wise. He was very strong. Quintay got 3 kids. Previous Quintay got a son. We brought him in the world January 4th. So Quintay lost his life August the 7th. So he really didn't get a chance to see his son. I hate this happened to both of the gentlemen. Mr. Tuitt, I want him to know I pray for him because not only he hurt me by shooting Quintay in his chest, every man knows that a mother's heart is the first love of a son is the mother. So he's gonna hold her right here on his chest. So when you shoot somebody right there, you indirectly talking to the mother. And to shoot him in his back is another symbol of, I don't want you to be able to walk again. That's not fair to me, and that's not fair to his mother. And I want him to apologize to me and his mother for causing us so much pain. Because we don't know each other. So he made us dislike each other. And I don't dislike his mom because I know she did the best she could with him. At some point in form, he don't have to tell me today, but when he sleep at night, just apologize to me. And also, before he leave this world, I want him to apologize to his mother. Because when we come in the world, they come in the world, we don't come with instructions on being a parent. So it's very hurtful to see your son treat another human being the way he did. And it's senseless on both ends for all of them. I watched the videos over and over and over, and I did not see a reason for what they did. All of them was wrong. And it hurt Judge Young. It hurt me to my soul to the point where I had to get therapy 2 times a week. And I'm on medication that somebody never did. And it's the first time in my life, of course, I've never been able to help my child. I couldn't help my son. And that's something I ain't never been able to not do. My kids depend on me. And it's 6 of them, 2 deceased and 4 living. All my kids are independent. My daughter right there, Rochelle Jones, she's very independent. I have another daughter, Charlotte, Tommy, and my other son, Cortez. So the impact this didn't hurt me, it hurt them. And it's the first time, if anybody has a parent, you help is when you see your children suffering like that. So not only did he hurt me, he hurt my children. He hurt Quintay's daughter, who's very, very fond of her dad, who's in therapy. He hurt his kids, trying to be a hero for the streets. He hurt his mom, and those are the only 2 people in his life I'm consider important to him. And that's his mother, his father, and his kids if he have any. So he owed them an apology. So I'm not here to damage him or bash him. I want to understand how he hurt everybody because we all hurting. So for the courts to take his life, it's just senseless. And I mean senseless. And I like the courts. Let Miss Fagan know Quintavious' name is Quintavious Keywan White, and she don't get the right to call him Smoke because I have never in my life called him Smoke. I don't agree with street names, so my kids know that about me. We can't control how our kids move above life when they go out in the world. We can only save them so far. And to damage his name, to make him look like he this monster, is not fair to me. And one day I want to apologize to me and my family because I never gave him that name and I never called him back that name. And I want Mr. Tuitt to know I'm gonna keep him in my prayers. I thought about him last night and I said, out of all these, they both lost. Kutave lost his life and he losing his life. And that's not fair to me, my children, his children, nobody. Cause he didn't have a reason. There's no legitimate reason. Judge, I'm not asking for links on what he did. Cause what he did Kutave was so terrible. It was so terrible to shoot a person when he already dead and then turn around and shoot him again. And he never took the stand and tell me why, not y'all, me, why he decided to hurt Quincy the way he did. That's not fair. And one of these days, I want him to tell the world. He just said in the universe, come a spiritual person to get that he is truly sorry for what he did to me and his mom. Cause I know his mom was hurting just like me. Cause she done did everything she can for him. Everything in the world. And this is what he give her in the end. He give her life in prison. That's not fair to her and to his children. That's all I have to say.
Ms. Wright, I appreciate you being here and sharing that. Mr. Tuitt left a hole in your life and your family's life that you can't fill. I didn't realize that Mr. Wright was your first son, and that's a terrible loss. You'll be grieving for a while. My hope is that this process brings you at least some closure. It certainly doesn't bring Mr. Wright back, but it shows you that people took this seriously and did something about it. I appreciate you being here.
Thank you. And I want to say to the court, the district attorney office, Mr. Adam Abadi, and this lady here, and this lady, they have dealt with me for 3 years, and I'm sort of hard to deal with. But I appreciate them for what they did.
Well, you have a basis for being hard to deal with right now. Your son was shot and killed, so I don't fault you at all. I guess I should add, I appreciate you bringing that up. I'm sorry that it took so long for this day to come. Cases shouldn't languish that long. I'm sure the prosecutors told you why there were some twists and turns and ups and downs. It was not because anyone didn't care about Mr. Wright or what happened. It was for boring legal and technical reasons. But the day has come, and like I said, I hope this does bring at least partial closure for you and your family. And I'm glad you have family around you still to lift you up.
Thank you so much.
Thank you. Ms. Jones-Connor, anyone else?
No, Your Honor.
Okay.
One moment, Your Honor.
Now would be the time to tender those convictions, if you have them, if you'd show them to Ms. Fagan first.
Hey, good morning, Judge. I showed them to Ms. Fagan yesterday. I was bringing them up early, but they were marked as State's Exhibits 150 through 153.
Okay, Mr. Abadi is saying you already got a chance to see them, although his numbering suggests there are 4. There really should only be 3, but.
I think he was doing the notice as well.
Oh, okay, so then that would make 4 exhibits. Well, let's just make sure that what Ms. Jones-Connor has is the same thing you saw yesterday, and then Ms. Jones-Connor can tender them. I'll see if there are objections, and we will move forward.
Thank you, Your Honor.
I did review them yesterday. Yeah. Yes. We have one as the, yeah, okay. No. Receive, Judge, 150 through 152.
152.
Yes, Your Honor. So because we have.
That's just the 3 convictions.
Yeah, sure.
Okay.
We'll tender those in since we've already been clear on the record about the recidivist notice and that
Okay.
was filed. Again, states 150 goes to the conviction in 12 SC 112693. States 151 goes to Mr. Tuitt's conviction in 12 SC 112694. And states exhibit 152 goes to Mr. Tuitt's conviction in 12 SC 112773.
Okay. Any objection to the admission of those certified copies, Ms. Fagan?
No.
All right, they're admitted. If you'll get them to Ms. Nelson, we'll get them to Ms. Rivers so they become part of the record. Anything else, Ms. Jones-Connor, from the state?
Nothing further from the state, Your Honor. Thank you.
All right, Ms. Fagan, I want to handle a couple technical things first, and then the rest is yours to navigate as you see fit. Did you agree with Ms. Jones-Connor's description of what would merge and what is vacated by operation of law, such that we're really talking about sentencing only as to counts 1 and 8?
Yes, Your Honor.
Okay, I did too. I want to make sure we didn't miss anything. Number 2, Mr. Tuitt is on probation now. And Ms. Simpson, who's on the call from probation, has been reminding me, hey, we should probably knock that out and just do a revocation. Assuming you and Mr. Tuitt are all right with it, my idea would be to simply revoke the balance, running it concurrent with whatever sentence flows from today. But I want to make sure I get that case number, which I have, on the record, and get you on the record saying we waive any due process notice rights, because I didn't put this down for a revocation hearing as well.
Yes, Your Honor.
Okay. The case is 19 SC 171734, and Mr. Tuitt has just over 4 years remaining on that. And so my proposal is to, as in light of the convictions from yesterday, revoke the balance of that, running that revocation concurrently with whatever sentence I impose today. Any objection to that?
No.
Okay, Ms. Jones-Connor?
No, Your Honor.
All right, Ms. Simpson, anything more you need me to say in connection with the revocation?
No, Judge, you covered it all.
Great. Last legal technical question. Do you have any disagreement with the state's proposition, Ms. Fagan, that the recidivist statutes sub A and sub C both apply in light of the 3 exhibits that were tendered?
No, Your Honor.
Okay, so we are operating under the recidivist realm, which means, Mr. Tuitt, I'm confident your lawyer told you this. I have very little discretion here. I am required by law to sentence you on count 1 to life without parole. Count 8 has to be consecutive, and that's where there may be a little give, but I'll hear from Ms. Fagan on that. A sentence after life without parole in some ways is just an academic exercise, but I don't want the sentence to be what we call an illegal sentence because it's structurally unsound. But that's where we are with my sentencing options. At the very end, I'll talk about your appeal rights, but now, Ms. Fagan, I'd like to hear from you. If Mr. Tuitt has anything to say, and you mentioned there was a family member or friend or more who want to be heard as well, and now's the time.
Yes, Your Honor. So I do agree that the court's hands are tied as far as the recidivist statute and the sentencing that applies in this case. We do have Ms. Stewart that wanted to speak on his behalf. Do you prefer?
She's going to go whatever direction Deputy Gordon tells her to go.
Yeah.
Hi, good morning.
Hey, Ms. Stewart, can
Hi,
you
how are you?
spell your last name for us?
Sure, Stewart.
All right, and how are you connected to Mr. Tuitt?
I've been knowing him since I was like in high school. I'm 30. Been
A
knowing him.
long-term friend?
Yeah, really
Okay.
long term, super long term.
All right, what do you want to share with me?
Well, I understand the situation and on both parties that it was just, unfortunate, but I've heard I don't know his name, I don't want to call him by smoke, but his family, he also has kids, but Tuitt also has 3 kids. He has a little girl She's 6. She looks just like him. And he also has a mother and a father, but his mother, father, not really around. He really had to raise himself, and had obstacles he had to, do by himself. And he really didn't have no guidance. He really didn't have no structure. He really didn't have anything to like help him, no father figure, anything like that. But for most part, he is a family man. Like, he loves his family, and he will give his shirt off his back for anybody. He is very, very kind. He's very sweet. He's not a menace at all to any society. He is just like, I met him. I was really, really young and immature, and he was just so quiet, and he didn't need nothing to like push up on me. He didn't try to like, he was just like trying to be cool, because guys like back in the day, well now anyways, but they're like very like aggressive and like, oh, what's your number? I want to talk to you. I knew he liked me, but it's just how he came at me. It was just different. So I like that he's just very gentle. He was very, very gentle with me. And he's been really, I'm sorry, I can't even talk. He's been rehabilitated. So, he just had to come by these obstacles, but he's not a bad person, and he will give the shirt off his back to somebody. And he's not a menace. He's really not. He's just a guy that just had a lot of problems in his life, and he's just trying to overcome those problems. And I'm sorry that this is the situation that happened. I'm so sorry for you guys. I really do apologize. I'm sorry. I really do apologize about the situation, but I would hate to have two black men, like, in a really, really tough, messed up situation. So I just want you to have some type of lenience towards him, because he does have kids, and he does have a mother and father, but no type of guidance, no type of security, no type of anything when it comes to like raising a kid. He was just born, he wasn't raised, So can you just please, like, some type of leniency, please, Judge, please. And that's it.
Okay, Ms. Stewart, thank you for being here. I know you were here throughout much of the trial, and I think that meant a lot to Mr. Tuitt, so thank you. Ms. Fagan?
Yes, Your Honor, I appreciate the court allowing her to speak, because she has been here and she wasn't able to be here yesterday afternoon.
Okay, I'm glad she had an opportunity to share. That's some insight into Mr. Tuitt's background as well. I got to hear about Mr. Wright, and there are two people involved. There's someone who was lost forever. There's someone who is being sent away effectively forever, but he's a person too, and learning about him is important. And that was good of Ms. Stewart to get through that. I know that wasn't easy for her. Anything else from the defense side?
I have a request. So yesterday he was sent straight to Union City. He wasn't able to get any of his items, one, and two, he's not getting. So usually my experience is, in this situation, a mental health counselor will come and check in, and nobody has. And I have a concern.
Okay, I'll help manage that. Does Mr. Tuitt want to say anything? And let me say this, Mr. Tuitt, before you answer to Ms. Fagan. You have a right to say anything you want right now, but you don't have to say anything at all. There's no burden or obligation, but I make an error if I don't give you, either directly or through your lawyer, an opportunity to speak. And I've let Ms. Fagan speak, but I want to make sure if you want to, you're given that opportunity. Does Mr. Tuitt want to say anything? No? Okay. All right, Mr. Tuitt. We understand, having heard from Ms. Stewart, that no one is monolithic. There's not just the guy we saw on the landing shooting Mr. Wright not once or twice, but 6 times. There's more to everyone. You're a father, you have family, you have people who care about you a lot, and I get that. What I'm faced with, though, is not the part of you that will give your shirt off your back. I'm faced with the guy who, in broad daylight on film, shot someone point blank range 6 times, taking his life. In some ways, we're fortunate that the only loss, and it's a forever loss, is Mr. Wright. It would have been so easy for more people to have been shot. Who knows, when officers get involved and they hear shots, what could happen? But we have the added tragedy that you are lost to your family, in the sense that you're not going to be able to be there on the holidays or the family reunions. They can come see you. You can't come see them. That is the price we exact from people who do what you did. And I'm going to seize upon one of the words Ms. Wright used, and that's senseless. I don't get it. I don't get why Mr. Wright's walking around with a gun in his waistband in an apartment complex with kids everywhere while you had a gun. And heck, Mr. Forte acknowledged he had a gun. It's an unfortunate circumstance that is the norm in some parts of our community. And I'm not blaming those parts of our community. I'm blaming our whole community because we shouldn't let it be that way. The fact that you were born but not raised means that the community let everyone down because you had to pull yourself up by your own bootstraps. We all ought to have at least a parent or someone who is assisting in some way, and a school system that means something, et cetera. But I can vent and rage all day long, and it's not going to change anything. You found yourself in your environment and made some decisions, and they may have been split-second decisions, although as Ms. Fagan pointed out more than once, actually it was a 30-minute process to which everyone brought guns, and we see what happens all too often. And the only silver lining I see out of this is that, again, Ms. Wright, you and your family have some closure, that people cared and brought this case. It came in. It wasn't easy for Mr. Forte to come in here and say what he said, and he risked some things by doing that, and Ms. Forte as well. So I think that's important that the process works that way. It doesn't bring Mr. Wright back. It doesn't give Mr. Tuitt a chance in 10 years to say, look, I'm changed. I got a degree while I was in prison and I now minister to people in need. You're not going to have that possibility for a rebound. Mr. Tuitt, I'm sentencing you count 1 as required by law to a term of life without imprisonment. Count 2, 3, and 4, those counts are vacated by operation of law. Count 5 merges into count 1. 6 merges into 8. 7 merges into 8. And 8 is 15 years to serve, and they will run consecutive to count 1. Mr. Tuitt, you have certain important appellate rights. You have the right to have a motion for new trial, which is an argument that a lawyer will make for you to me, that there were mistakes made at trial or in your sentencing. That means we ought to do this all over again. You also have the right to a direct appeal to the Supreme Court to make all those same arguments. You actually can do both. You and Ms. Fagan are going to talk about whether you're going to do both. And the first you do would be the motion for new trial. And if that doesn't go well for you, then you have your right to directly appeal to the Supreme Court of Georgia. You have only 30 days from today to do one of those two things, to start that process. And I'm going to ask Ms. Fagan to stay with you at least long enough to execute your wishes. File that placeholder motion for new trial or file that notice of appeal. Then we will work through whether you want Ms. Fagan to stay on as your lawyer, and I'm assuming that would be something you'd have to afford, or if you are going to hire a different lawyer or you need one appointed. It is typical that a different lawyer comes in for the appeal because one of the things the lawyer looks at is not just did McBurney make a mistake and let something in that shouldn't come in, but did your lawyer make a mistake? Was there something that she should have done that she didn't, or she did that she should not have? And Ms. Fagan can't make those arguments about herself. She's not legally allowed to. And so sometimes, I'd say more often than not, a different lawyer comes in. And that's not you having a vote of no confidence in Ms. Fagan. It's just getting another set of eyes to look at the record. You and Ms. Fagan will talk about that. I will ask Ms. Fagan to stay involved long enough, at least to file either that notice, that initial motion for new trial or notice of appeal. You've got 30 days to do that. If you miss those 30 days, those rights are gone. You also have what we call habeas rights, and that is 4 years after your conviction is final, which would be either you exhaust all your appeals, or if you don't do anything for the next 30 days, then that 4-year clock starts running. Within those 4 years, you or a lawyer you hire, you're not entitled to one, because I'll make sure you have a lawyer for the appeal I talked about. You've got an absolute right to that. But on the habeas side, you either do it yourself or you or friends or family pay for a lawyer. That habeas you don't worry about until all your appeals are done, unless you skip the appellate step. Do you, Mr. Tuitt, have any questions about your appellate rights? Okay. Ms. Fagan, will you confer with Mr. Tuitt and honor whatever his direction is for that first step?
Yes, well, I'll file the motion for new trial.
Okay, great. And then someone on my staff will reach out to you. Initially, you may be filing a withdrawal, and then we'll sort out with Mr. Tuitt, maybe through you, is he bringing someone on board or do we need to appoint one? And we'll go whatever direction you provide.
I think initially it would be safe to appoint someone.
Okay.
And, because I expect that the arguments will have ineffective issues.
Sure.
And I expect that, that in the event that he is able to retain, then he would retain, but ultimately, just to keep the process moving.
I think that's wise. He can always bring someone in at any point. Hey, my family or friends have hired so-and-so, but in the meantime, we'll look to get appointed counsel upon seeing that motion for new trial that you file.
Yes, Your Honor.
You raised two questions about Mr. Tuitt's mental health and his belongings. If he has things at Rice Street, I'll work with the sheriff's team to make sure they make their way down to Jackson. Mr. Tuitt is not going back to Rice Street. Jackson is, as you know, a diagnostic facility, and day one, they plug in with Mr. Tuitt to see how he's doing and not doing. So I'm not as concerned about that as if he was going to languish here for a few weeks until GDC came to get him. But I have it on good information that he'll be headed there right away. So I'll work with the sheriff's team to make sure that legally permissible belongings go from Rice Street down to Jackson. All right? Ms. Jones-Connor or Mr. Abadi, anything else from the state?
Obviously, I knew what you meant, Your Honor. When you were pronouncing the sentence, you said life without imprisonment. I think you meant
Without imprisonment. Well, that's not what I meant. Life without the possibility of parole. Don't get the wrong impression on that one. Life without the possibility of parole for count 1, followed by 15 years consecutive imprisonment for count 8.
Then, obviously, this is my mistake about us, seeing if the court could ask counsel to ask members of the Tuitt support group. There were several people who supported Mr. Tuitt, which obviously is great, but they have, after they've left court, they've taken photographs of the Zoom or the YouTube, especially of Mr. Forte and his mother, and posted pictures of them online with rat emojis. They actually posted Ms. Forte's address last night, saying that not only is her son a rat, but the whole family is a rat. This is where they live. So maybe we could ask a request that that not occur.
Okay. So, Ms. Fagan, you're going to do what you think is right. Your connection to the case is limited going forward, but I know that we've got Ms. Stewart in court as well as, I believe, Mr. Tuitt's sister. And I would encourage you all to advise friends and family members. I'm not saying you all had anything to do with it, so you don't need to say anything in response. You can just nod your head saying, I've heard you, Judge. It can result in felony criminal charges if people are connected with efforts to intimidate witnesses or obstruct justice. And what was just described to me, if true, would fall into that category. So people are running into some dangerous waters if they're doing something like that. So insofar as you all have influence over people who are passionate about Mr. Tuitt, give them some good advice to dial it back. It's okay to be upset, angry, hurt. All those things are natural, but it's not appropriate to direct those feelings to people who came in here and testified under oath. If it is documented that things like that happened and it's sourced back to an Instagram account that belongs to, I'm making this up, Fred Tuitt, Fred Tuitt's gonna have some trouble here in court. So let's just keep that as quiet and safe as we can. Thank you for flagging that. I apologize for my misstatement of the sentence. Ms. Fagan, thank you again for coming into this case and from the defense side, finally moving it forward. Anything else on behalf of Mr. Tuitt?
No, Your Honor, not this time.
All right, thank you. And I would ask one last thing, Deputy Gordon, you can decide. One side of the room needs to leave first. There are only 3 folks here for Mr. Tuitt. Maybe they go first. And I'd ask the folks here for Mr. Wright to sit tight until a deputy says it's okay to go. You all right with that? Thank you.
We don't know the words to say, I didn't hear anything. I don't know, it's no separation. I feel for you guys, but I know from the bottom of this heart. And I don't care what the streets say, I don't care, I know it. I know, and we both, all of us know what was the problem. But that didn't matter. It didn't matter. And we apologize for the things. I'm so sorry. Thank you.
All right, all right, thank you for sharing those words. We're working on the paperwork. You already sent it? All right, it's not here yet, but did you just send it?
Oh, wait, no. I got you something.
Okay.
You know it. Yes, ma'am.
Yeah, I'm gonna sign it right now. I just need to make sure it doesn't say life without imprisonment. Not this one?
No. I got.
Life without parole?
Yes.
Okay. All right, folks who are here for Andersons and Davids, take the tables. I think the Davids lawyers would be over at that one.
Judge, may I be excused?
Yes, ma'am, Ms. Simpson, have a great weekend.
Thank you, you too.
Yeah, I don't have it yet, but when I get it.
And I had to make sure I had the A's.
The tables have turned, as they say.
The tables have turned. And you actually staying here to speak? Or you guys want to?
Life without imprisonment.
Is that what you said?
It's what I believe in. That's not what I meant.
Because Ms. Simpson said it too, and I was gonna tell you, and then that's when Adam said she heard the same.
Yeah, no, I'm
They're all looking out.
Judge,
Yep.
I caught it. I had changed. it
Thank you.
already.
All
I
right.
was gonna tell you about it later.
Yeah, yeesh. They're all here for him. They're serious about it.
Yeah.
Print it?
Yes, please.
Okay.
That's bad.
How many copies?
How many copies you want?
How many copies you guys need?
Two, take two, please.
You just need to tell me. 3? Can it be double-sided?
Look, I said two, you said three, okay. 3 to work.
3 it is.
You want that other one? Yeah.
I hope it works. This printer sometimes works. I will. Oh, it's working.
No, it's like.
Yeah, you just go down 75. I think it's before Gypstick. It's not too far. You're talking about Jackson? Yeah. We got a tour. Watch these guys getting their heads shaved. This dude with massive dreads. Everyone gets their heads shaved.
Thank you so much.
It's pretty exciting. They're all, and then they come in and like, oh, hey, it's me, zing. Like, oh, now everyone knows. There you go. All right. All right, giddy up. All right.
Say it. All right.
Thank you, guys.
Easy.
Will you guys let Colonel Edwards know?
Yes, sir. You're ready to call?
Thank you. I want to get off her bad list. Yeah. Are you ready? Okay, this is 2021 CV 348101, Andersons versus Davids. It's October 10th, 2025, and we are here to talk more about attorney's fees. There was a jury verdict that awarded the Davids all of their attorney's fees, and in some of the pleadings challenging the outcome of that jury trial, counsel for the Andersons pointed out that given the fact that the Davids were not universally successful, in fact, the Andersons received a judgment, zero liability, but one verdict in their favor, it was legally improper for the Davids to be awarded all of their attorney's fees. In looking at what had been presented during the trial, I didn't find that I could come up with a fact-based way of reducing the fee award so that it more accurately reflected work done in support of the grounds where the Davids were successful, and that was for two reasons. One, the data wasn't quite that granular in a way I could process it, but two, sort of everything is connected. There's two sides tussling over these easements and right of access and what did the easements mean. And so defending against a claim from the Andersons was simultaneously promoting a counterclaim from the Davids. And so it was muddy, and the right thing to do was to hope you all could settle it, but I'm mindful of how this case was litigated, so it was only a very slight hope. And short of that, it was bringing everyone together. So if we could please get on the record, appearance for the Andersons, and then we'll do the same for the Davids.
Kristen Medwick on behalf of the Andersons, Your Honor.
Hello, Ms. Medwick. Appreciate you being here. It looks like you might not be 100% comfortable, but it's great to see you.
Doing the best I can.
All right.
Randy Edwards, also on behalf of the Andersons.
Hello, Mr. Edwards. How you been?
Very good.
Good. And on behalf of the Davids.
Jeff Schneider.
Casey Stern, Your Honor.
And welcome back from Coffee County to both of you. I want to apologize to both sides. We're starting about 45 minutes late. I had a murder trial that was supposed to be last week, but we had to start it this week instead. And so I've had to overlay it on top of everything that had been scheduled. The lawyers thought it would be done yesterday, and in fact it was, and we got a verdict around 2:30. But the defendant wanted, I now know it was Ms. Tuitt, to be able to be here to say something on his behalf. And she mysteriously, although she had been at the trial the entire time, left right after the verdict. So we had to move sentencing to today. For those of you who were in the courtroom during the sentencing, you can understand why it took a while. It involved the loss of life and put something like this in perspective. But we'll still talk about attorney's fees. So I'm going to start with Ms. Sturm or Mr. Schneider to see where you think we are and how you're proposing trying to slice and dice this. I will always give Ms. Medwick and Mr. Edwards an opportunity to respond to anything, so we don't need to object while we're doing this. If I'll hear from one side, then I'll hear from the other side. I have a time constraint, and that is that we've got about an hour, 10 minutes this morning, but I will be back. And so if we don't fit it in then, we will either reconvene at a date that works for you all that's not today, or we can reconvene this afternoon and you can have a nice lunch in downtown Atlanta. There's actually, surprisingly, this hotel just opened right next door to the courthouse, and it has a medium restaurant in it called Social Capital. Because otherwise it's, well, you guys were here for a trial for a while. Hopefully you brought your own lunch most of the time, because it's American Deli. We lose jurors after they eat at American Deli. So, Mr. Schneider, if you would.
Your Honor, our proposal and how we anticipate proceeding today, we understand that these claims, as is not atypical in title and real estate cases, are very, very intertwined. My anticipated testimony was by Ms. Sturm to go through the timesheets that were submitted. And she has highlighted certain sections of these timesheets which may give the court some advantage in figuring out what went to where. They're color coded, so some would go to the appeal. There was a pre-lawsuit TPO that was brought, and we've segregated those out. And she can walk you through those, which may be of help to all parties to see, okay, these things are, as I understand, the Anderson's position shouldn't be in the suit. But as to the overall fees, Ms. Sturm's testimony will be, as you've sort of foreshadowed, that there is so much intertwining of these. It's the same property, same people, same underlying nexus, being this this mercurial easement that went up and then back down from the Court of Appeals that was at the heart of it. So it was really impossible to say, well, I took part of Mr. Anderson's deposition for trespass and one for nuisance. Really, ultimately, all it would be impossible to segregate those out. But my anticipation is that Ms. Sturm can very summarily take the stand, walk everybody through what she's prepared, and perhaps that might shed some light on the court and give the other side some opportunity to understand it a little bit more clearly also.
Okay. Ms. Medwick or Mr. Edwards, what was your plan, other than obviously responding? It's not your burden here. Were you planning to be reactive here, or did you have a proactive piece as well?
Your Honor, I mean, I have gone through the billing.
Did you get, I'm sorry to interrupt you, but did you get the color coded?
Yes.
Okay.
Close to 5 p.m. last night, I got it.
Okay.
But I have gone through, I kept everything from the trial, obviously, because we are where we are. I have gone through the billing multiple times and, you know, should this become relevant later on, I've done, spotted anything that looked like counterfeiting to me, marked those, calculated those fees. Certainly I have some questions about some of these billings. But, you know, I guess we know what the law is, we know what it says, so I'll be interested to hear the testimony.
Okay. I have one last nugget that entertained me. I don't know, that'll make Mr. Edwards as happy. I have a case and Edward Anderson versus David was cited in it for the proposition that the easement grantor can use the doesn't lose the property and can use it as long as that use does not interfere with the grantee's enjoyment. And the word enjoyment was used of the easement. That's what the lawyers, that's different set of eyes reading it, but I was tickled that that's how lawyer X from big fancy law firm read, and it was nice to see Anderson David in there. They didn't say where Judge McBurney was reversed. So, well, why don't we get Ms. Sturm on the stand? Well, before we do that, how do you want to manage the time? In an hour-ish, I need to go away for a while, and then I can come back. If your afternoon is free, or you may know, hey, this is a 5-minute presentation. That's not how this case is typically rolled.
God, I would anticipate that her direct on this maybe 15 minutes.
Okay.
I'm not having her go through each line item. I don't know how long they might take to cross-examine or I ultimately see it coming down to the legal argument.
Okay, well, let's press on and as we approach the 11:30 moment, because I meant to give you guys 2 hours and then murder came in. So let's get rolling and we'll see where we get. Right up there, Deputy Gordon, can you swear Ms. Sturm in?
Raise your right hand. You swear affirm that the testimony will give the truth, the whole truth, nothing but the truth, self God. I do. You know, and I see, and you say it's very name in the record.
Sure. Casey Sturm, last name is Sturm, S-T-U-R-M as in Mary, first name Casey, K-A-S-E-Y.
If you want to be able to see the screen, no, don't unmute, hit stay mute, click that. Then you can see, in case they're going to be exhibits, you can see them better.
I'm sorry, did we?
She's sworn, it's official.
Okay. Ms. Sturm, please state your name and occupation for the record.
Casey Sturm, attorney.
And can you give us a bit of your legal background?
Sure. Product of the public schools here in the state of Georgia. I have an undergraduate degree from the University of Notre Dame, and a law degree, JD, and I have actually a dual degree from Vermont Law School, Juris Doctorate, and a Master's of Studies in Environmental Law. Obtained that in 2000, and commenced working right away. Moved back to the state of Georgia, and despite my best intentions not ever to litigate cases, I commenced a month-long trial in the Office of State Administrative Hearings on the first discharge into Lake Lanier, the Upper Chattahoochee River Keeper. And from there, it has kind of continued. I have litigated, I guess, for the past 25 years in the area of my focus in law is environmental, land use, condemnation law, zoning, and it covers a broad range. So I went to Vermont Law School because I was determined to practice environmental law, thought that would be in a different sphere. And what you quickly learned in that arena is that environmental law touches almost every other area of the law. Real estate law becomes extremely important for environmental issues. And so my career over time started working with Upper Chattahoochee River Keeper, representing a lot of nonprofit groups, I segued into a nonprofit practice where we represented groups throughout the state of Georgia. And from there segued into what we call public-private interest law, and essentially working with a lot of mom and pop companies or individual property owners, addressing impacts to property. So that ranges from contamination, from things happening nearby. It also deals with the issues that are involved in this type of case, property disputes among neighbors. That's kind of a brief background.
What percentage of your practice is in litigation?
Right now, it feels like 100.
Maybe higher than that.
It feels possibly higher. Certainly, I think it's 90 to 95% generally, and right now it's at the high end.
You're here to testify today about the fees in this case. How do you determine the rate or fee structure for your work?
Sure. Fees are determined a variety of different ways. So most commonly in my line of work, and with the firm, we handle things on what we call an hourly basis. And that is typically based on the attorneys involved in the case and the experience they have. There are times that we may work under a contingency arrangement or a mixed fee. Those are really very dependent on particular facts and circumstances of a case, as well as other issues, maybe geographic. My work varies mainly throughout the state of Georgia and South Carolina sometimes. And so there are other factors that may go into it.
Yeah. And for purposes of determining your rate for this case, what did you consider?
If I recall correctly, without the records in front of me at present, the rate for this case was $4.25 an hour, which is a standard rate in the industry for someone with my years of experience, and comparable to other folks that practice in the same realm with the same level of experience. Much lower than you would see at perhaps the big firms, but comparable in that mid-size range. In this case, again, I think the other thing that was involved this case in that what we call the COVID period, and so while the firm at time may raise rates, given what was happening in the world at that time, I think we had decided to hold rates where they were.
Let me hand you what's marked as exhibit number 1. Ask you if you can identify this document.
Is this an exhibit you've already provided to counsel for the Andersons?
It is.
This would be the 5 p.m. exhibit, one of them?
One of the 5 p.m. exhibits, Your Honor. Yes.
Okay.
So number 1 is a copy of the firm's billing records for this particular matter, our clients, the Davies. This, if I recall correctly, is the same exhibit. I think it was a defendant's exhibit 35 that was submitted during the trial. This is now a marked up version of that exhibit.
The contents, the 65 pages, were tendered during trial. What's changed is the color coding.
That's correct.
There are redactions on many pages. Those are not new redactions.
That's correct, Your Honor.
So exhibit 1 for today's hearing is basically exhibit 35, whatever it was in the other situation, with the color coding added.
That's correct.
Thank you.
And I recall you may have testified at trial that this exhibit reflects the true and accurate time records for this matter.
That's correct. So on the first page, again, you have a summary that shows you different employees that may have worked on the particular case matter. It'll show you the hours expended. It'll show you the fees associated that, and then the totals. And again, this one, the summary sheet shows a time period from October 26, 2020 to March 5th, 2024, which, again, going off memory, I believe is before the start of trial on this case.
And we would tender defendants or exhibit number 1. I'm calling it exhibit number 1 for purposes of this hearing.
Okay. Ms. Medwick, any objection to exhibit 1?
The only objection that I would have is the markups, as it really appears to be attorney notes rather than, you know, like, she should be able to identify her own billing, rather than have note taking or highlighting to do that. I don't think that's appropriate for an exhibit, so I wouldn't object to that, but other than that, no other objections to this exhibit.
Okay, and when you say the markups, what I see on here is for some entries, it's not many, but some, there's some color coding. There's a purple, there's a green, I think I saw a red somewhere. I don't see like handwritten notations, but certain entries have a color highlight applied to them. That's what you're objecting to?
Yes, because I mean, it's, you know, when you have an exhibit, you're not really allowed to have note takings on your exhibits to help you at trial. And color coding could be exactly that.
Okay, I'm going to allow it in. I suspect that the color coding is meant more to be helpful for me in segregating things out. But I'll note that they are additions that the attorneys have made. And so I'm not going to treat it as this was what the original document looked like. But I will allow exhibit 1 in over your concern.
Thank you.
You're welcome.
Let's walk through this exhibit. As opposing counsel just noted, there were some highlights. And if you can give us your color coding key by telling us, as we walk through this exhibit, what those reflect, or what was the intention, what was the origin, and why did you do that?
So a couple of things. One, I think the intention is probably, as the judge indicated, was to help the court and maybe process this in a timely fashion. When we look at the billing records, as in any case, so time is kept by the attorneys, essentially contemporaneously with activities that are being worked on. I was the lead attorney on this case, so ultimately how things work at the firm is that the billing, while maintained by each attorney, will be reviewed by me before any bills are processed. And that's to ensure that one, the time being kept is consistent with the time being worked on the case. As with any case, there's a starting point of contact. As I indicated with this one, it indicates that we were contacted in October of 2020 by the client. That being said, work did not really commence on this case until January of 2021, in which case that's where you see the time entries on the particular case. What's typically common is it's not uncommon for somebody to reach out to the firm. We will do a conflicts check, that kind of scenario. Oftentimes, you know, it may be that we have talked to a potential client, they feel like maybe they're going to work it out, and maybe they don't ever call us back. In this case, obviously, we were called back and work commenced in 2021. And what you really see is the initial commencement of the lawsuit. As you walk through the fee records, you will see kind of the communications that are happening at the beginning, the actions taken by our office to address the David's concerns. Two things were happening at the same time. One would be, it's not uncommon to start any litigation or any legal matter, I should say, with attempting to avoid litigation. And so that is what happened in this case, a cease and desist letter was put together. At the same time, there was some unfortunate communications between the two parties that resulted in a TPO action being filed.
Okay. And are the TPO related charges on this exhibit the ones that are highlighted in yellow?
So you will
Objection, lady.
Overruled.
Again, as I was indicating, at the start of this case, there were two things kind of going on. One, cease and desist letter, ideally to avoid litigation. At the same time, we have an unfortunate circumstance going on where the client is feeling threatened, and so a TPO action is taken. I did not handle the TPO side of this action. Counsel or colleague at the time, Brandon Arnold, was primarily responsible for the TPO action, but because of its ties to the underlying issues in this case, I continued to oversee the work on that. And so highlighted in yellow on this document 1 are time entries associated solely with the TPO action.
Okay.
And if you flip through, it looks like from page 3 through 10, perhaps there's time entries during the time that this case is transpiring, where there's involvement both on the TPO issue and then separately related to the underlying claims again in this matter.
Yeah. So if an issue were raised as to billings related to the TPO or allocated to the TPO, the court would look at the yellow highlights.
You could segregate time out related to the TPO by, yes, adding up the time from the yellow highlights. Again, the issues here, the TPO is separate, deals with, restraining orders related to the individuals. The underlying issues involved in that all stem from the same issues in this case, the easements.
So this the TPO didn't involve a car accident or a dog bite, right? It was the same underlying easement dispute.
That's correct.
And the ultimate result was a TPO obtained, it was denied, or the Davids decided not to pursue it?
So initially, my understanding is initially entered, there was a hearing. I think the court indicated that they often deal with issues vastly different from this one, and we're hopeful that the neighbors might be able to work it out themselves. And
So there was a court appearance, but ultimately no TPO was entered.
and I don't want to misspeak only because I think there was one entered and then there was the court appearance and it was not extended.
Okay.
If that makes sense.
It does, that it can flow that way.
So let me move you to page 11. We've gotten up to that point. And this includes the dates, at least as the top of that page on Exhibit 1 is in April of 2021, right?
Yeah, so again, a case is any case is going to, run through some sort of process. When I'm talking to a client, I'll often say it's a little bit of a roller coaster in the sense that, you may be taking some sort of action and then you're often waiting. So there's sometimes a lot of uptime and a lot of downtime. This case didn't necessarily follow that because of different things happening at different times. So for example, while the Davids sent a cease and desist letter, that was met with a lawsuit as opposed to a response. And so in this particular instance, there's not a lot of, we're doing something and then waiting for a response.
Sure.
There's a lot of things happening at the same time.
It,
And so on page 11, you will see, us acknowledging service of the complaint that was filed by the Andersons against the Davids. You will also, the highlights shown on page 11 or starting on page 11 in red here. Again, the Andersons sued the Davids over the same easement issues. So ultimately, when we're talking about the claims in this case, they are all intertwined.
So we can save that for argument. One, I led with that. I get it. What would you say red characterizes? I see a number of red highlights. If you were to tell me red is, it's not the TPO. So it's.
So what I was gonna say is red is specifically a motion to dismiss the claims brought by the Andersons.
Okay.
Okay.
Remind me, was there one filed and denied, or there was one contemplated but never filed?
It was filed.
It clearly wasn't granted because.
It was denied. I
Okay.
believe there was an amendment to the pleadings.
Okay.
And so the highlights that you'll see in red pertain to issues that would have gone along with the motion to dismiss.
Okay, but to your point, it's all related to this easement, and is there a basis to challenge the David's use of it, et cetera? It just happened to be a motion to dismiss that ultimately was unsuccessful.
That's correct.
Okay.
And so the highlights that you see in red carry the motion to dismiss. If you proceed throughout this case, there are some in lime green. I think they start on page 28.
I see the lime green.
If you see the lime green, you'll note if you go to the far right where it says build, under build values, it has an amount. It shows 0. And this was, if I recall correctly, we noted this for the jury as well. This is time that we would call, in your fee records, there may have been an issue we were talking about with the clients, it's unrelated, right? And so it's been no charged. It's documented, the client knows that it occurred, but it's not been charged or billed.
Okay.
Okay.
So I don't need to exclude it from anything because it is not part of the universe of billings.
It is not part of the universe of billings.
Okay.
That being said, I don't want to mislead the court. And so this summary on the top page, judge shows a total for an amount, right? The total in this particular exhibit, if you flip to the very back of the exhibit, you'll see on pages starting at the bottom of 59 and carrying to the end, you'll note that the time starting in February on this exhibit is all going to show a 0 in that last column, right?
Okay.
And that's because the way this document works for the firm is that February bill had not gone out at the time this report was generated. So it had not been billed. It wasn't no charge time.
Okay.
It was not billed.
They're not highlighted in lime green, so they're not things that were no charged by the firm.
That's correct.
Okay.
Okay, but with the ones in lime green, I would suggest that the tally of those no charges, because of the way this document was created, does come off of this total figure.
So the 262,000 actually includes dollar amounts that are, let's make it easy for me. Go to page 36, please. So you called Stacy David and spoke for 6 minutes. So you billed $42.50. You worked, but you billed 0. Is that $42.50 in the 262,000?
It is because of the way the report was generated. It's generating a worked.
Okay, and so where does one find what the total is if you add up all of the billed value? So the final column on every page is amount under billed values. Where does that sum show up?
So that sum does on this report show up on the front page. It needs to be reduced by what was not actually charged to the client. So those line green amounts.
So it's not billed. There's a line on the first page, billed, and that figure is about $30,000 less than the total. Does that $232,000 reflect the sum of all of the numbers in the amount column under the billed values heading?
That does.
Okay.
So the 232 would give you the build up to February, whatever that date was on.
Yep. Okay, so the 232 backs out all of the dollar values of the lime green.
That's correct.
Okay, all right.
Let me move you to page 53.
Okay.
Page 53, we start seeing some blue highlights. What was the reason for your highlighting those time entries as blue?
The blue highlights reflect, as this court is aware, there was an issue that went up on appeal. The blue highlights reflect time spent on the appeal. There is time incurred during that same time period. Of course, things are still happening even while the case is on appeal.
Okay.
So if the court wanted to not award those or adjust, that's how the court would find those time entries?
That's cool.
And the last two pages of that exhibit, 64 and 65, that under the list of expenses, are the color codes the same? In other words, related to the colors in that you've previously testified to?
That's correct. It was the same. That would be, filing fees associated. The one in blue would be associated with appeal. The one then red would be associated with the filing fees for the motion to dismiss. And yellow would be associated with TPO.
Okay.
Yeah.
We skipped a color. Purple.
Purple.
Page 61.
Thank you. Page 61, Exhibit 1. What does purple reflect?
So, the purple reflects, I believe that's motions in limine. So this case also, I think right before the appeal, we were about to go to trial and we had prepared motions in limine. And then there was the appeal, so we had a pause. So the timing, I think they were renewed right before the trial commenced. These are motions in limine that reflect essentially the same arguments that were raised in the motion to dismiss. So they were motions in limine geared directly at the claims raised by the Andersons. We'll leave the context of that for argument, but that's, if you wanted to look at them, that's where you could isolate those out.
Okay.
This may be formality, but based upon your experience in trying cases in the practice of law, are you able to render an opinion as to the reasonableness of the fees, the hourly rate that was charged by you and others with the firm in this case?
Yes, I mean, the fees and expenses that were charged in this case, in my opinion, are reasonable and necessary for the presentation of this case. And
I see that I was charged at $275 an hour. I want to.
unfair advantage to Jeff. Jeff actually has 30+ years of experience
Fair enough.
in real estate issues,
Okay.
title companies and whatnot, but agreed to come on in essence, Brandon had departed the firm, and so Jeff agreed to come on.
Just so that the court is clear, as to Exhibit 1, the time reflected in the exhibit reflects the time and related fees incurred associated with the claims on which the Davids prevailed, correct?
That is true. Again, the claims in this case are interrelated, so there isn't a way to specifically parse out individual claims associated. You don't have time entries, for example, that would be associated with the Davids trespass claim specifically. You wouldn't, there's no way to take those out.
Let me hand you what has been marked as Exhibit number 2. Ask you to identify this.
Thank you.
So exhibit number 2 is the billing record. So this is March 6th, so still pre-trial through March 15th, which would be the close of trial on this case, if I recall correctly. So together, 1 and 2 would give you, in essence, the time and expense records through trial.
Exhibit 2 doesn't have any color coding because we're not dealing with an appeal during Exhibit 2. We're dealing with the trial and prep just for the trial.
That's correct. This is prep time for trial and trial time.
All right. Ms. Medwick, any objection to the admission of Exhibit 2, which does not have attorney markups on it?
Yes, Your Honor. And the reason for that is we're here today, this was a jury verdict, and the jury saw Exhibit 1 today, which was Exhibit 35 at trial. That's the evidence that they were given to award attorney's fees, and we are trying to parse that out. This was not presented to the jury. This is inappropriate today, and I would object to this.
Okay. What I'm going to do is admit it so that the lawyers for the Davids are going to make whatever argument they make. You make a compelling one, which is now we're adding things to the mix that the fact finder didn't have and could not have used to come up with their number, which I've already said is too high. Not faulting the jury, they didn't know any better. But it answers one of my questions, which is, well, what about the billings after that time? But the complete answer is, in some ways, it doesn't matter. There may be argument as to why it does matter, but I'm going to write on here, jury didn't have this. I have it, but I think unless there's some case law I'm not familiar with, the jury drew a line in the sand that we can't go above. This whole exercise is about going below that number in a reasoned, structured way, as opposed to they won 2 out of 3, so 2/3. Hopefully that's not where we end up. But I'll admit it over your well-placed objection, and I'm actually kind of acknowledging the objection, but I don't want to keep this information out. That makes sense.
Yes, Your Honor, and I just would add to the objection, there was testimony about this exact time frame, which we argued was extremely insufficient. So it would be my position that, this could have been available at trial, and it was not.
Well, I don't know about that part, but I certainly should not and will not use this to say, oh, but look, there was that testimony at trial, look at Exhibit 2. Not how it's going to work.
Okay.
So I'll admit it just so we're making the record complete. But my reliance on it is more of a, okay, that's interesting. And it is kind of close to whatever testimony there was about that. And I know the two sides have argued that, well, maybe the number that the jurors got to was what was documented plus some math they did to say, well, it clearly cost the Davids attorney's fees to be here at trial. But then you're getting into that realm of more speculative than anchored by a document like this. So yes, on both points, I'm still letting it in just so that we're making the record.
Thank you.
You're welcome.
Okay, let me hand you what I'm marked as Exhibit 3. Ask you to identify it.
Thank you, sir.
Exhibit 3 runs from the firm's time and expense records for this particular matter. And it runs from the conclusion of trial through October 7th.
So
3 days.
3 days ago. How, anticipating an objection to the admission of 3, Mr. Snyder, as lawyer handling this examination, how is Exhibit 3 relevant to what we're working through?
To the extent that the court could consider with the intent of the jury being full attorney's fees as referenced in the verdict form.
Okay.
It simply presents what that would be if
Honoring their request.
as I'm duty bound to do.
Okay. So you acknowledge that it represents money spent, time spent, money that the Davids need to work through, that is all after the fact of the verdict.
Correct.
Okay, got it. So you go ahead and lay the foundation and we'll go from there.
Exhibit, I'm sorry, I've gotten muddled in that. Describe
So
what's.
exhibits 1 and 2 would be the time, up through trial, that would show, what are the reasonable and necessary fees, through trial.
And in your opinion,
Exhibit 3 shows, the reasonable and necessary fees that have been incurred since trial through 3 days ago. We did highlight some sections on Exhibit 3 that we don't contend would be associated with this particular matter.
There's more going on with the Davids and the Andersons. I guess I should have asked you all, like, do they still live next to each other and don't love each other? Or actually now, like, someone's daughter married someone's son and now it's like there's a grandbaby who is an Anderson David.
there's a lacrosse team being formed.
A lacrosse team.
So there are highlights on Exhibit 3 that we would.
But wait, what's the answer to my question? Did they remain next door neighbors and not besties?
It appears so.
Okay. I just wanted to update. I jogged by there once and wondered, should I knock on the door and see like, hey, how are we doing? Okay, too bad. Back to your answer.
Yeah, so there's just time highlighted on there, that we would not contend is related to the specific issues.
Okay,
And
got it.
So, understanding there will be heated objections, we tender Exhibit 3.
Okay. Knowing that I'm going to admit 3 just so we make a complete record, please do get on the record. You don't have to do all of them. You probably have 10, but like your top 3 reasons why 3 has nothing to do with what we are working through.
Absolutely, Your Honor. 13611 is clear that should attorney's fees be awarded, therefore the successful prosecution of the counterclaims in which they prevailed, that ends at trial. Obviously, the jury didn't hear this. And in addition to this, we are here today because of a failure of allocation for the attorney's fees. So it's not that, they prevailed again and these should be awarded. We are only doing this work because there wasn't an error.
Okay.
So I absolutely object to this.
Okay. Well, your absolute objection is noted. I think you have
Strenuously object.
many valid legal points. Can't knock the David's lawyers for trying. And just to make the record complete for this hearing, I'll admit 3, but that strikes me as being even further afield than 2. But you gotta give credit for creativity. The jury did say full fees, and because you all are still fighting, the fee amount is growing. So I understand the reasoning behind it, but I also understand the focus that we've got, which would be what possibly could the jury have been thinking about, and it wouldn't have been anything that happened after they said, thank goodness we're done with this case, and they got to leave.
It just for the purposes of our record today, while that was their original award, they were instructed to change it because that's an improper award, so we should not really put too much credibility in full amount.
Well, I don't want to ever discredit something the jury says. They were delivering a message they wanted to deliver. It just was not a legally valid one. And so we had to say, try again.
Fair enough, and so they ultimately put a number on it, so we're not here to discuss quote unquote full amount.
Right. And they didn't put an asterisk to say, including anything that they have to spend in the future. Okay. All right, let's keep going.
In anticipation that the Andersons may ask you questions about the allocation of these fees among claims, counterclaims, defenses, and so on, is it your opinion that the underlying claims were so intertwined that it would be impossible to segregate or apportion them?
So we provided the court with the areas where you may be able to identify if you wanted to try to extract, for example, the TPO, highlighted in yellow. Again, what's driving that is integrally related to the claims in this case. Necessarily, though, we highlighted to show you where those fees could be pulled out, okay? Similarly, a motion to dismiss, a motion in limine, the appeal issues, all of those issues are tied into the claims and how the presentation of the David's underlying case. So while we have highlighted them, they are so interconnected that it's challenging to sit there and say that these are not reasonable and necessary in the presentation of the David's claims. They go to the very heart of those claims as well.
All right. And I'm hoping we don't spend a whole lot of time on the reasonable word. These billing rates are truly unremarkable in this legal market. I think it's going to be, it was necessary in the sense that you're defending and prosecuting. It's really, to me, the nut we're trying to crack, if it's crackable, is how do you allocate? And when you can't allocate, is the answer then no award? And how is that fair? But how is it fair to say, I'm going to guess, and you've possibly over allocated? So I hear what you're saying, and I think you can see what I'm wrestling with.
Yes, Your Honor. And to that degree, I guess one way I could go about it is we could go through all of the pleadings in this case. In my own mind, because those are the record of this case already, would be to simply argue that, A begat B begat C, and for these reasons, they're inherently intertwined.
Okay. Do you have more questions for Ms. Sturm?
I do not.
All right. Ms. Medwick or Mr. Edwards, do you have questions for Ms. Sturm?
I do have questions, but I would, based on the evidence presented by them, I would make a motion for a directed verdict. They made no effort to allocate actually, I would like to make 2 points. It's not clear at this time if they're saying the highlights should come out or not, because they put that in the intertwined argument.
So what I heard is that they identified areas that if I conclude, well, at a minimum, anything to do with the appeal needs to come out. They have said, here's what had to do with the appeal. And that would be blue. I might decide, well, no, the appeal is part of this process, and so it stays in. It doesn't solve the deeper issue, which is how ultimately do we allocate? But I heard them say, we're not so sure you need to take them out, but should you decide structurally TPO, that's not this case, take out those numbers, then I know just subtract the yellows, that kind of thing.
Okay, well then, so to that point, there's been no effort whatsoever to allocate these billings, none. And as you can see in Exhibit 1, they're heavily redacted. There clearly is more information there that could be available to me, to Your Honor, to see what was the billing of this. But it's very intentionally kept out. And the case law is clear. Their duty is to allocate their successful counterclaims. They've had plenty of time to go back through these bills and really put some effort into it. And the law is also clear that the jury, when they got this, speculation isn't enough. Guesswork isn't enough. It's their duty to allocate these. And to that point, they included this in their answer, defenses, and counterclaims. They are smart.
They included
competent-
what?
The attorney's fees. Your
Okay.
Honor. Smart, competent individuals with the knowledge that maybe they could win attorney's fees, going into billing, making no effort to allocate, well, these are our counterclaims. Here's what we spent time on for these. There was a way to do it. They chose not to. And when you look at the billing, a lot of it is block billing, heavily redacted. And here today with the opportunity to explain, to present unredacted attorney's fees, there was simply no effort. And I don't believe that they've met their burden.
So do you believe that the case law is such that if a judge makes a finding that it's not possible to disentangle, let's say make it simpler, it's just there's a plaintiff, there are no counterclaims, and the plaintiff says trespass and nuisance. And the jury finds for the plaintiff on trespass, but not nuisance. They award full attorney's fees. Well, the plaintiff didn't win on everything, but everything they said about trespass, they also said about nuisance. They're technically not the same, and it's true during trial. At some point, a lawyer for plaintiff would say, and let me tell you about nuisance, in opening and in closing and arguing with the judge about a jury charge. There would be some moments in time where you could say, really, all she was talking about was nuisance. But really, when the person is advocating, they're saying, we win because this was a trespass and a nuisance. And the jury, for whatever reason, said, we'll split the bait. We'll give them trespass, but not nuisance. Didn't give anything to the defense. Clearly, it's just a straight plaintiff verdict. Is that plaintiff unable to recover attorney's fees? Do we divide by two because there were two kind of co-equal claims? Or is the case law, if you can't do it, you lose. You cannot get attorney's fees? Because I haven't seen that case that says if the judge concludes that there's not a reasonable way to break the billing into here's when I was thinking about trespass versus here's when I was thinking about nuisance, because they are of a single thing, then that they don't get to collect attorney's fees. Even as soon as it's so clear there was bad faith so don't get into, I know there's a separate argument, hey, there wasn't bad faith. That's not what today's about. So how there's a case that says that plaintiff gets 0 attorney's fees.
So the wording of the case law brings you to that conclusion.
Okay.
Because it clearly makes the burden of proof, the attorneys have to allocate recoverable fees versus unrecoverable fees. And merely providing a lump sum of the attorney's fees and expenses of litigation incurred in working the entire case lacks sufficient particularity, justifying the award of attorney's fees. And that's essentially what we have here. We have a lump sum where maybe you can take stuff out, but maybe you don't, which would essentially lead to the exact same verdict that you've already ruled was too high and wasn't allocated. And again, the case law, and I am looking at it's Premier Cabinets Inc. versus Bulat, 261 Georgia App 578. Again, broad statements contained in billing and a billing account fail to demonstrate the function of the task with sufficient particularity, permitting the jury to distinguish between time and expenses attributable to successful claims, thus forcing the jury to speculate, and that it can't be based on guesswork. And so I understand what you're saying with your position and how you might be challenged in getting there, but I think this predates you having to do that. I think they have a responsibility to bill in a way that's clear. You don't have to do block billing. You can do several line items of billing, and when you know you've asked for attorney's fees and that you may not be successful on all of them, it's in your best interest to say, spent this much time on X issue. And in this case, there are clear delineations. I mean, the interference of the words that were spoken from the Andersons to the DeVies, that's its own thing. Some of the other allegations with interference, they're very specific. The brandishing the gun, the cameras, the words, those are extremely specific. Conversion was the chair. the clearing of the easement. Those are very specific events that you could actually bill for. You could parse those out. So to your example, I don't think that these are that inextricably intertwined that you couldn't at least make efforts to allocate them.
If your side had been victorious at trial in the way, I mean, I appreciate there was a judgment for the Andersons, but if in the end it was attorney's fees for Andersons, would your billing records have been put together in a way where it would be real easy to see, here's where she's working on trespass, here's where she's working on nuisance?
I do bill specifically, but unfortunately I wouldn't have been the one to recover that because I was defending. So it wouldn't be my bills, it would be.
Okay, but right, but you two have been working together. I'm just curious, you make it sound like it's real easy to do, and it may be. I blessedly have never had to bill hours, just get paid public servant money. It seems like in some ways that wouldn't be too hard if, hey, today I spent a lot of time thinking about the filming of the little boy or something like that. I don't know where that falls in there, but that's not nuisance maybe. And so you would say this is excludable because we was researching how that might be a privacy violation or something. But it also seems like on either side of the V in this case, there would be a whole lot of work being done that advances everything you're trying to do. And so you can't say, well, I just spent 2 hours working on, take the appeal. Let's say the appeal money. If the judgment had been for the Andersons in such a way that they recovered attorney's fees, I think there'd be a real good argument to say, and we should collect on this appeal because the judge got it wrong. We had to spend this money fixing this, and we go to trial, and finally a jury gets it right. But that appeal really had to do with everything. I don't know how you would segregate out. And I know you didn't have to do any of that, but conceptually, you make it sound like there are these easy buckets into which to put the mental work lawyers do. And that, to me, seems like you're creating a interesting but not realistic model.
My reading of the appeal, I know I was a latecomer, but I read everything in the file and then some. The appeal actually doesn't address any of the counterclaims. It's the construction.
Well, so bad example, but my point is that it sure seems like there would be things that attorneys in this case would be doing where they spend a lot of time thinking and writing and preparing, where it is to be ready for nuisance and trespass. I don't practice in this space or in this structure. But you'd be so disciplined to say, all right, I have a count for trespass, and I have a count for nuisance. I'm only going to think trespass right now. I'm only researching trespass. I'm not thinking about nuisance. Oh, but this is related to I have to stop. I have to push that thought out of my mind. Oh, I have to subtract a minute now because I just thought about nuisance. That doesn't count for my trespass billing. Really?
I don't think I'm taking it that far.
Okay.
I know, and I appreciate what you're saying, but I don't think I'm taking it that far because when you're litigating a case, what's the purpose of what I'm doing right now? What issue am I researching right now? Am I researching interference versus conversion versus trespass? And actually, the interesting thing about these counterclaims is they are distinctly different from each other. So much so that we were able to tell the jury, here's what this is for, here's what this is for, here's what this is for.
So fair point, and I'm seeing that more clearly. I suspect that you all spent a fair amount of time with at least Mr. Anderson, maybe both, about their trial testimony, prepping them. Hey, let's go over how this is going to go. And I suspect you talked to him about lawn chair as well as other things. And my bet is in the billing, it is prepared Mr. Anderson, and it doesn't say spent 37 minutes on conversion and 21 minutes on, and so is that one you just look, we can't collect on that because that's not allocable?
If you decided to keep track of your time where you went through the specific issues, you could do it. However, I do think it's kind of, if that's going to be your position, we had to do this all together. I can't allocate this, you say goodbye to that charge.
Okay.
And I think that's what the law would suggest too.
Okay. Do you want to ask Ms. Sturm any questions? You've made a potent argument, and I think it's also sort of your summary of what we do here. Is there anything that you want to ask her?
Yes.
Okay.
Because, yes, I do have questions about, and I'm gonna be going off of Exhibit 1.
Okay.
And I know you have an 11:30 time.
Right, so we got about 10 minutes before we need to break, either for now and come back later today. I see a whole lot of Post-it notes on there, so that may be more than 10 minutes worth of questions. And I'm not limiting, you can't have a day of questions, but you can have more than 10 minutes. Do you want to get started, or should we talk about when we're reconvening?
We can get started and let's see how quick I can do it.
Okay, I don't want you to rush in any way. I want to be clear. The murder is what made us late, not that things have taken too long. So why don't you get started, and then I'll tap the brakes in a few minutes and we'll figure out next steps.
Thank you. And do you still have Exhibit 1? Okay, wonderful. All right, so let's go. Will you go to page 49 and the first entry? Okay, so it looks like on that entry, you contacted David Shostak, and then you also did an assessment of communications regarding the gun brandishing and video and all that. And I believe those were related to the interference claim. Is that correct?
Well, if you look at the entry, it says it's a discovery review. So there's a couple of things going on here, looking at discovery related to the claims as a whole.
Understood, but you did actually specifically point out what you were reviewing. Is that correct?
Those are some of the things that would have been reviewed related to the discovery review going on at that particular point in time.
Okay, and these were issues that were addressed at trial, correct?
I don't know if I understand what you're asking.
So these particular issues, the brandishing the gun, the video, David Shostak as an expert, those did appear in trial, yes?
These would have been, things that were discussed or entered into evidence during trial.
Okay. Going back to David Shostak, because he was the expert for the clearing, correct?
Yes, he was an expert that opined as to a value associated with clearing.
Okay. And so on page 36, it's January 20th of 2022. And it says deposition of David Shostak.
Yes.
And you billed 4.5 hours for it, correct?
Mm-hmm.
Okay. Do you remember if the deposition was in person or remote?
I don't recall as we sit here.
Okay.
I'm curious, I don't want you to reveal any trade secrets. The entry right after it says preparation for deposition, and then something's redacted. What kind of thing would need to be redacted right there? I get it when it's spoke with client about, and then the rest is redacted, because who knows? But would that be a name that is redacted, or?
It is probably some kind of notation that was made in association with the preparation. So like an attorney note that was put in there.
I mean, like UGG, or I'm just curious what would need to be redacted for something like that?
So it is typically, so one would anticipate that maybe this would say preparation for deposition of so-and-so. I don't have it exactly in front of me.
I know you don't know what it says, but I'm just, why something like that?
It would be because it's got some kind of attorney note on it. So
Okay.
some comment was made about the preparation.
Okay,
And that's why it got rejected.
okay. It can't have been very long, so it was like a word, like urgent or crud or liar or something. All right, okay.
And do you remember when David Shostak's deposition started?
As I said, you're right.
Okay. May I approach your honor?
Yes, ma'am.
Okay. If you need to take off a clip, that's fine, but look at this and this page I'm pointing to, and let me know the other side. Because I can refresh your memory. It's on that page. That's what I'm asking you.
Oh, started at 2:08.
Okay, thank you. Do you remember what time it ended?
I don't.
All right. If you'll take a look at that page, let me know.
5:09.
Oh, thank you so much. So by my calculations, that's 3 hours and 1 minute. Do you disagree?
Not for the deposition.
Okay, but you billed 4.5 hours.
Correct. It likely includes additional time post deposition regarding the issues that came up at deposition.
Do you know for sure that that's included in your billing?
I would say it's likely that that's what's included in the billing, because typically following a deposition, we will do both notes to file and we will do follow-up with a deponent.
Okay, so likely.
Sometimes we'll have a communication with the clients as well.
And that might be what all the stuff that is redacted refers to?
Correct.
On that same day, do you recall what deposition you were prepping for?
I would assume, well, I shouldn't do that because we also did the Andersons depositions. So it's possible that that is preparation for the Andersons depositions.
Okay, all right. Do you recall what day you filed your answer defenses and counterclaims?
Off the top of my head.
Are you able to find it in the billing?
May 24th is when you filed your, just so you can find it in the billing. Of 2021.
Okay, yes.
All right, and do you recall what day the special master was appointed?
I don't recall off the top of my head, but I would, I don't know if it was before or after that.
Okay. May I approach, Your Honor?
You have continuing permission to approach.
You know if that refreshes the memory.
There appears to be an order from this court on April 21st.
Thank you. And I know you testified, I believe you weren't sure if the TPO was granted or not. Is that correct? Or do you know that it was not granted?
My understanding of the process was that it gets filed, maybe it's like a TRO in the sense that the court can enter one before it holds a hearing to decide whether it gets extended. So my understanding was the TPO was entered and then a hearing was set fairly quickly and it was not extended further.
Okay, so would it be fair to say that the judge denied the TPO?
Again, I don't know the best way to characterize that. I think the judge denied extending the TPO.
Were you present at that hearing?
I was not.
Okay, all right. Okay, so you really don't have any personal knowledge about that separate action, correct?
I wouldn't say I don't have any personal knowledge because I was managing Brandon, who is handling it. I don't have personal knowledge of the hearing itself.
And that's really what I meant, not from what somebody else told you, but you weren't present. You don't have that personal knowledge of hearing for yourself what the judge said.
Not from me.
Okay, did you ever read the transcript?
I believe portions of the transcript may have been read at some point in time.
Okay. Okay. And sitting here today, your testimony is that you are unable to go through Exhibit 1, look at line by line and allocate what work was done to what issue, whether it was defense, counterclaim, which counterclaim, other than what you've highlighted, everything else you're unable to allocate.
I do a lot of work similar to this type of issue. I do a ton of cases that deal with nuisance, trespass, inverse condemnation, interference with use rights and property. The claims in these particular cases, and I know from y'all's side you may not like it, our work is dedicated to what we're doing. So this case was unique in the aspect that we sent a cease and desist, and the response was, I'm going to sue you instead. I think that's what Mr. Edwards told the jury, is that a demand letter makes you a defendant. Nevertheless, our work is still geared towards the claims that our clients have. And those claims, why the jury didn't come up with trespass, I don't know, because there's case law that says a conversion will.
Ms. Term, I understand that, but I asked a specific question, so can you answer that?
I'm going to interrupt her. It's a long answer. If she doesn't answer it, you can always say, well, let's start with a yes or a no.
Okay.
So the claims in this particular case and the time that is kept for them, to the best of the ability, we went through to isolate particular issues that we say, hey, you can go through these time records. For example, the TPO, very clearly, here's the TPO. We've highlighted it in yellow to show if this time you want to take it out, those are the time entries you would take out. The rest of the claims are all interrelated, whether it's the Andersons claims or the Davids claims. These claims all have the same facts and circumstances as the basis for them. We're not, in most instances, relying on different witnesses or individuals. It's the same pieces of property. It's the same facts and circumstances giving rise to it. So in the vein of, are there things you can highlight out with particularity? Again, our contention, trying not to make a legal argument, but for items like the motion in limine or the motion to dismiss, if you wanted to say, here's time specifically spent on those, I still contend that how those are dealt with is interrelated with the claims we are pursuing, right? Nevertheless, we did highlight those out. Then all the other time entries, all of that goes to the same underlying basis for these claims in this case.
So I take that as a no to the question of, could you have allocated by claim?
Could you have allocated specifically by claim?
Right. You're saying no.
No.
And you did not bring an unredacted version of Exhibit 1, correct? We don't have that to look at. Is that fair to say?
That's fair. It's not entirely redacted, but that's fair.
Okay, I mean, a lot of redactions, but either way, this was how it was presented to the jury. It's presented the same way today. We don't have a copy to show any unredacted, like completely unredacted. We don't have that, correct?
Not completely unredacted.
Okay, all right, okay.
We got to wrap up.
And I think those are all of my questions.
Not so fast.
We need to go.
Okay. Your Honor, I have no further questions.
Okay. You can step down. I assume you didn't have any redirect.
I do not.
Good answer. All right. We need to break now. One option would be, if those have been admitted, we'll want to leave them with the court reporter. Would be that we reconvene this afternoon. Another would be we reconvene on another day. And a third would be, because that's the evidence that the Davids are advancing, we then can, if you want to brief it, you can brief it. Frankly, I think, Ms. Medwood, you've already argued it. And you may want to say, and look at these 5 cases, and then it could just be a letter. I want to make this as unburdensome as possible. You're not collecting attorney's fees for your clients. You're billing them as you should, but it's not like the light at the end of the tunnel is my clients will get something back for this. It's an avoidance effort now. So I want to, whatever fits best. So why don't I start with you, Ms. Medwick, as to how you all want to wrap this up. You may say, look, we're done. You heard what you needed to hear.
I would like either the option of closing arguments or briefing it. For practicality purposes, I think resetting it to another day doesn't make sense for me.
Okay.
So probably would be on maternity leave.
Right.
So.
And Mr. Edwards would be adrift, so it's important that you be here.
But I think we also want to conclude this, so I want to find the most efficient way. And if that's just simply doing a brief of what our closing arguments would be, I'm fine with that. If everybody wants to stay, I'm fine with that too.
You know, I didn't think of plan 3.1, which would be, you don't have to stay. We could do it by Zoom. Now that we've had the sworn testimony and you were able to confront CEO, she didn't make eye contact when I asked her questions, all that kind of stuff. I'm also fine having people connect via Zoom. I want to impose the least on you all. And so if you want to be back here at 2, we can do 2. If you want to be back online at 2, we can be online at 2, and I can just keep this Zoom running. Or it could be, you know what, I'll get you 5 pages in 2 weeks, whatever deadline works in terms of getting a brief. And it could be 10 pages, not more than 10 pages. So if you want to confer about that and let me know, I'm going to step back there for a second and come back here with my I gotta go clothes on. All right?
But I'm fine either way. If we want to come back at 2, if we want to do.
It's fine with me.
That's fine.
It's whatever y'all settle.
Okay.
I'm fine.
I mean, now that it's just.
Yeah, I accepted the.
Yeah.
What's that?
No, but.
No.
No, let's just.
Okay.
Yeah. Two.
Oh, how will that work for our court reporter though?
I can stay.
Are you sure that's
Yeah.
a long time to stay here?
No, it's fine.
Are you sure?
Yeah.
It's like I got other stuff I can do, right?
It's all right.
So you guys coming back at two?
We will be.
On Zoom though.
Or is it Zoom or in person?
We can.
He
just come
said
for-
Zoom.
He said either way. He can do it either.
Oh, if we're coming back at 2, it's gonna need to be Zoom for me.
Okay.
Cause there's just no way.
Yeah, that's fine.
Yeah,
Yeah.
time wise, I can't make. work.
Yeah, that's fine.
So Zoom at two?
Feel good with that?
Fine with it. That court order, deposition and everything else. But he had to take breaks from the court. And getting the rest from him was very complicated.
It was very complicated,
okay.
because I had to ask for some things, different things, what I asked for. And
Yeah.
he's a super nice guy.
Oh, yeah.
He is, but it's,
He is.
I believe, you know, he's a service, so it's like.
Yeah.
Fine, it's those things in here too.
Yeah. There were a lot of that. We set up. No, it is funny because
Zoom at 2?
Yes, sir.
Zoom it too.
Okay. How are you going to work it with the court reporter?
I can stay here if that's okay. I can be in the hall meeting and I can do it
So
with you in
up
here.
to you. I'll be sitting right here when we do it. So however you want to do that. You can coordinate that, but let's all pop back on at 2.
Are we gonna get emailed the Zoom link?
Yes.
Awesome.
No, only one side.
Yeah, and then the other side forfeits.
Yeah.
Your Honor, if I happen to be, I have some other things I wanted to take care of in the courthouse. If I happen to still be here at 2. can I-
Courtroom will be open.
Okay, otherwise, my house is 5 minutes from here, so it'll be one or the other.
Mhm. Testing. Mhm. Can the people on Zoom can hear me?
I can hear you.
I can hear you. Beautiful. For the person Deidre Nelson, um, who are you representing for today?
Oh, it's me. I'm the litigation manager. I'm just on.
Beautiful. And then same question for L. Thomas and E. Logan.
They are with my office.
Okay, great. Mr. Edwards, is it possible you can provide me their first names?
Yeah. E. Logan is Eric Logan. He's my associate. And L. Thomas is Lauren, Lauren. She is my assistant.
Thank you so much.
Mr. Bobadilla, you ready?
I'm ready, sir.
Okay. Well, let's get back on the record in 2021 CV 348101. Today was not a day for me to be on time. I apologize for that. I'm glad some of you took advantage of the Zoom option so you could be in your office or home or wherever you are. For our friends on the David side, you're just getting an extra dose of Fulton County today. But I got back as soon as I could get back. We closed the evidence. It consists of exhibits 1, 2, and 3. Primary focus on exhibit 1, as well as Ms. Sturm's testimony. It sounded like the parties agreed to have a little bit of oral argument as the way that we wrap this up. So I will start with counsel for the Davids, and then we'll hear from whomever on the Anderson side. And then if there are any final parting words, I'll hear back from the Davids.
Thank you, Your Honor.
Before you dive into it, Mr. Edwards and Ms. Medwick, are you able to hear us?
Yes, sir.
Yes.
Excellent. Okay. Then we don't need the witness screen anymore. And if you could adjust the monitor, you should stand wherever you want to stand. I just need you to show up, and that's the screen there, but it moves. And so if you don't want to stand back away from if you angle that and then angle it up, or you can stand back, your choice. Here you go. Okay.
There we go.
Excellent.
Your Honor, I'm going to pick up where we left off, which is the rules regarding proof of attorney's fees. And opposing counsel pointed out the case of premium as really her primary source of authority. The problem with that case is it doesn't deal with the issue here, which is where there are intertwined issues. It doesn't really say what to do under those circumstances.
What do we do with intertwined issues? That's really what this is about.
Well, from my perspective, the court being the trial court, and effectively, Your Honor, what you've done is saved a remand on this case because it could go up and the Court of Appeals could hear this argument. And from my reading of the opinions coming down on this issue, it's almost always on remand. They don't just trash them out in the appellate courts. They send it back here for this conversation. So it's valuable to all parties to be having it. But in terms of the exception to the apportionment rule, the general statement is grounded. The exception to the apportionment rule is grounded in the impracticality of separating fees when claims are intertwined, which is a point that you were getting to earlier. Now, of course, if we look at plaintiff's attorney's fees exhibit, it was profoundly redacted. I think I remember a Goose Gander argument being made during that hearing about how we were complaining about theirs and then they complained about ours. But you'd see a similar practice, not being critical of them or critical of ourselves, but primarily saying it's not uncommon that we see some redaction. It's also extraordinary if we see, and in fact, I can say in 35 years, I've never seen time entries that were so specific that I could say, on this half of the deposition, we focused on murder, and then the others, the lesser included offenses. But the rule applies primarily, and there are different scenarios in which it comes up, but where there's a nexus between all the underlying claims. And it's extremely consistent in real estate boundary cases, and in this case, easement cases, where both sides are complaining about the other's conduct. It's both sides, the merits of them would turn greatly upon the location of the common boundary line or the interpretation of the easement agreement. But pulling one drags the other one across. You sort of proving my case, disproves their case.
Defending against the claims in the complaint is also advancing the claims in your counterclaim.
Right, and that's inevitable. And usually one side wins on the interpretation of the easement and the other side then loses necessarily all of their claims. Court of Appeals did some interesting maneuvering on this case and made both sides sort of equal, which didn't solve the problem, frankly, for either side and continues to be, I think, a source of some disagreement. But My point being that you have a common nexus between all of the same facts, the same claims, the same parties, the same witnesses, and all of them turning upon the respective parties' perceptions of their rights, what they can do one across the other. And which as a litigator would make it impossible for me to sit through a deposition and say, these questions will be for my trespass nuisance conversion claim and also against their claim of my trespass and nuisance and hurt feelings or whatever their claims are. It is kind of touching on the language. It's impractical to expect lawyers to do that. And I think the rule has been applied to prevent a forfeiture when a party does convince a jury to find bad faith, which happened here. They obviously intended to grant fees or award fees in this case. And so they were left kind of with what we have in the record, which is, in my opinion, fairly ordinary time entries, which reflect I did work on this case and may have spoken to Casey and so and so. But those cases are the ones that, there is a long line of cases that uphold this intertwined case. I think both sides would have been faced with the same issue, quite honestly, and both from mutual complaints about redaction and also the generic way. I don't think you could find, and if they were intent on arguing it, I suppose they would have tendered their time entries to say, well, look, we did it a different way. There was nothing unusual about that. So, in my opinion, the courts also conclude that the trial court has the authority to render that determination of the intertwinement. Part of the reason of having Casey testify was to at least share her own opinion that based upon her preparation and trial of this case, they were so inherently intertwined that she emphatically said, no, they could not be segregated out. I think if you went through that practice, it would be a fiction, frankly.
So what are a few cases upon which you rely to say there's a long line of cases, the impracticality of separating fees? The trial court is empowered to effectively declare intertwinement, that
right.
It's a fool's errand to try to split this atom. It is not, we've reached that fundamental unit of matter. It is unsplittable.
That's right. And I think you would find it in the Wilson versus Winowski case. It's 355 Georgia App 834. And also the D versus Sweet case. That's 218 Georgia App 18, which held that where a common core of facts provides for the basis for several claims, each derived from related legal theories, attorney's fees on all related claims are permitted. And that was followed in several other decisions. One was Cray. I think I may have misspelled it. I've spelled it Cravey versus Johnson. It's 327 Georgia App 213. And Huggins versus Chapin, which is 233 Georgia App 109. All of those both recognize this exception and also recognize the trial court's authority to make that determination based upon a showing of a party trying to advance these fees. And that is, in the bigger picture, our argument. They've asserted a couple of specific arguments relating to, and this is the genesis of Casey's color coding sections of the billing records, was to, if the court looked at these and said, I'm inclined to take these out, the highlights were specifically to address the points that they raised in their objections, one being the TPO being a separate action. And in their position, they cite the case of Alston versus Stubbs, 170 Georgia App 417. That was an action that was brought by an individual, and he was trying to recover attorney's fees that were incurred in a third-party action in previous litigation, which really was separate and apart from the underlying case. I mean, in our present case, the TPO proceeding was just the beginning of the string of events that gave rise to the ultimate conduct that was complained of and prevailed upon. And I think if 13.611 looks at the bad faith, not during the litigation, but in the events leading up to the litigation, I think it's relevant, and I think we should be able to recover those. And just for your own help, assistance, I'll tell you what the amount of each of those were. The TPO fee, the TPO total amount of fees and expenses was $3,499.45.
So if I added up all the yellow, I'd get $3,499 and how many cents?
45 cents.
Okay.
The red was relating to the motion to dismiss. You know, in our opinion, that was not dispositive one way or the other. It was just part of the underlying litigation of this case, asserting our defenses. For whatever it's worth, that number was $3,464.00. The lime green, I frankly am drawing a loss on what way we were talking about with the lime green.
Was zero. They were all things where there was an amount of time worked and there's a dollar value associated with it, but it was never billed.
Correct. And then blue was the appeal.
Yep.
That number was $18,942.50. They cite a case for that, which was Kent versus Brown. It was 248 Georgia App 447. And in Kent versus Brown, the party made the unusual motion to the Court of Appeals asking for all of their attorney's fees as part of the appeal. And the Court of Appeals, I think fairly nicely said, you can't do that. You have sort of two other options. You can apply for fees, which is limited or capped at some level. But that's really not ultimately what we have here. We're not looking for, we would like to be paid in advance for the appeal that isn't inevitably going to happen. But in this case, the appeal was not dispositive of the case. It was as much the active litigation as being before the trial court. They were advocating one position and we were continuing to advocate it somewhere else. It was just in a different forum, and it came back and it shed light on the respective rights of the parties, and the parties proceeded on. It's significantly different than a post-trial appellate detour. So we believe we should be able to retain that. In short, those are our positions.
All right. Thank you very much. And on behalf of the Andersons.
Good afternoon, Your Honor.
Hello again.
Hello. So just to kind of, you know, we were here today with the objective of what fees can be allocated to the prevailing claims. That is the rule for 13.611, and the case law is very clear on it. And certain things cannot be included. Things like outside cases, the temporary restraining order. The court has made very clear that appellate proceedings cannot be considered in attorney's fees, and a citation for that is David G. Brown, PE versus Kent, and that is 274 Georgia App 849. And of course, they're not allowed to recover fees based on defenses of the Anderson claims. So their argument and their position is that it's so inextricably linked that they can't do it. And they cited a case, it was the Wilson case, that was 355 Georgia App 834. And here's a distinction, because what that case says was that it was apparent that the attorneys tried to allocate as displayed in the exhibit as far as was practicable. When we look at this exhibit, it is so heavily redacted You cannot make that conclusion from Exhibit 1, and you can't make that conclusion from Ms. Sturm's testimony, because quite frankly, when she was asked about specific things in the billing, she couldn't remember. And that's fair. It's been going on for 4 years, but the redactions themselves are excessive. There are things that are redacted where you can look and see, well, why on earth would that be redacted? Conversations. There's a conversation with me that's redacted what we talked about. That doesn't need to be redacted. I was part of that conversation. I wouldn't have redacted that. And some of these redactions are so large that clearly there was some specific billing going on. And I pointed out one to Ms. Sturm on the stand that actually, and I did it on purpose, because it went to the interference counterclaim. So clearly that was a specific allocated billing that they were able to do. And those would be fees that they would be entitled to recover in this case. So they've kind of contradicted themselves with, we absolutely just cannot allocate these fees, when in fact they have. They also were able to go back and determine what was the TPO, what was the no billing fee, what was the Court of Appeals, and the other one, which was, let's see, the motions in limine and things like that. On top of that, and I did this because, as I told you at the beginning when we did our brief openings, not only did I look at the billing multiple times, I cross-referenced it with pleadings, with emails, with anything in the file that I could see. And of course, the court has pleadings stamped in, but things like motion to dismiss, the cross motion for summary judgment, and the appeal, that went directly to the construction of the easement, which was pled by the Andersons, and very clearly a defense for the Davids. There was no mention, and we know there are 3 distinct counterclaims: interference, conversion, and trespass. It doesn't go to those. It goes to the construction of the easement, which was brought by the Andersons.
But I hear you. I hear the argument, but until we construct the easement, what is the easement? For what purpose? Are there limitations on it? And how does it limit the Andersons' ability to use and enjoy the land? Don't you have to construct it before you can decide if someone has infringed on it or limited someone's interest? This is the interconnectedness that I appreciate you resisting it. You need to for your argument, but how can you do one without the other? And so in defending against what the Davids might feel to be a too narrow construction of the easement, in other words, the Davids think, no, it gives us more, and the Andersons are going to articulate a view of it gives you less, and that's the correct interpretation. That's the way to construct the easement. Those are part and parcel of, well, did you interfere with our ability to use the easement? Well, you didn't if the proper construction is that the Andersons can remove foliage. I'm making something up, but just walk with me on that one. So how do you say, yeah, you really were responding to what was, I'm going to call it a thrust from the Andersons, when it's a parry from the Davids, and that is all one sword fight. And not over here, we're having a gunfight, and over here, it's a barroom brawl.
I think the distinction is the fact that the Court of Appeals actually didn't answer that. The easement says what it says, and it clearly, gives the Davids some form of rights. And the question was really for the Court of Appeals, do the Andersons have no rights to the easement? That's really what they were deciding, because the decision was exclusive meant that the Davids could exclude the Andersons. And so the Court of Appeals was weighing on that, and they specifically said, we are not going to get into what actions would be permissible or not permissible. So which goes directly to the counterclaims. So that's not even something that the Court of Appeals contemplated. And so while sure, they may be, living in the same neighborhood, they're not living in the same house.
That's probably a good thing.
Right. Especially in this case.
Yes.
But so, that, and it's my argument, Your Honor, that also no billing that predates the counterclaim should be considered as well, because it's very different from when you're contemplating filing a lawsuit and when you're contemplating filing a counterclaim. And Ms. Sturm even testified they did several things pre-suit to avoid litigation. So there's actually evidence that there was no preparation for a counterclaim, and it would make sense that there isn't, because you can't prepare for a counterclaim unless there's a lawsuit. And I believe that takes you to page 13.
I know you were defending here, but I want to explore that request to exclude any billings pre-counterclaim. If things had played out such that the Andersons were entitled to attorney's fees, then would it be the case that you and Mr. Edwards would be acknowledging no money, no billings before we filed our complaint should be included when it's bad faith, and maybe Mr. Edwards spent dozens of hours trying to get the Davids to do the right thing in a peaceful manner? Peaceful is the wrong word, but I'm not suing you yet. So here's a letter, here's a phone call, I'm having to deal with Schneider and Sturm. And so I billed 70 hours before it was clear we were going nowhere. They were not engaging in good faith. They kept encroaching in a way that I put in writing they shouldn't do. And so now I've sued. And I win the lawsuit and the jury finds bad faith. Your position, as I'm understanding, would be, but you're not entitled to attorney's fees until you actually filed that complaint, even though some of the best evidence of bad faith might be the conduct leading up to the decision to file the complaint. Because the Davids didn't need to file counterclaims as long as they were working through a demand letter and this and that. But a demand letter is a whatever we've now heard many times from Mr. Schneider. That's an invitation to a lawsuit that he says, Mr. Edwards says. So it seems like it would work in both directions. And I'm not familiar with successful plaintiff's attorneys, meaning successful in that proceeding, saying, oh, all that stuff before I had to sue, I don't get to try to collect that.
Well, a couple of things on that. I think that, sure, the jury found bad faith, and that allows them to collect attorney's fees, but it doesn't necessarily establish a timeline. And what we do have from testimony and things that we know from the trial and things that you can glean from the billing itself, those actions spawned different actions. The TPO, the cease and desist letters, those weren't lawsuits. They were other courses of actions that you can't claim in this suit because they aren't part of this suit. And so I think that, to your point, sure, those things matter because they go to establish bad faith, and bad faith can be difficult to establish. So certainly it's relevant for a jury to decide, is there bad faith here? But it doesn't necessarily start a timeline for attorney's fees. And when you're talking about prosecuting successful counterclaims, and I do think that there's a distinction between filing a complaint and filing a counterclaim, where, but even to that point, it would depend on the billing. What were you doing and for what purpose? Mm-hmm. And at what point did you become litigation minded? So clearly, the Davids were not litigation minded, and according to their own attorney's testimony, until they got sued. They wanted to avoid litigation. They've stated in their place at trial and here that they weren't going to file a complaint. That wasn't their intention. So you can't contemplate filing a counterclaim until you've been sued. And my reading of this, and I think that it's supported, by the testimony and what you can glean from the billing is that other actions outside of litigation without contemplating litigation were taken, and those things are not recoverable here.
Okay.
So that then brings me to a couple of things. First of all, I want to address the inextricably linked because I don't think it applies to this case. As I already mentioned in the motion for a directed verdict, the actions related to the counterclaims are so distinct and so specific. And the jury itself was able to determine which counts they were going to find in favor of the Anderson and which counts they were going to find in favor of the DeVites. They had no trouble with that. And so I think a real hindrance here in whether or not this can be allocated are the redactions. And like I said before, some of these redactions are really, really long. So that tells me that the entries for the billing are specific. And so it seems like, the DeVites are kind of making contradictory arguments. We've heavily redacted these. There's nothing in evidence to show why this level of redaction was necessary. So we can't allocate it. But perhaps if we could see what the billing was, we would know one way or another. So it's almost like they're using their redactions as a way to say, we simply can't allocate. And I think that that's very damaging for this case because not every case is like that. If it was, then that wouldn't be an exception. It would be the rule. And again, pointing to the Wilson case, that was an exception because the court found that the attorneys really tried to allocate. You don't have that in this case. There's no evidence whatsoever that there was any attempt to allocate. And in the same contradictory vein, we do have some things that are allocated. So clearly it was possible. So I don't find this case, in my opinion, I don't think that this is one of those exceptions. And I think it's hiding behind redactions. And so, again, and like I said earlier, you can see that through pleadings, and you can see that through the little bit of testimony that we had today. And today was the opportunity. I mean, we had this hearing on the motion for new trial essentially a year ago. There was opportunity to go back and say, all right, if the event happens that we're going to have to prove these attorneys' fees and we're going to be tasked with allocating, what can we do? It could have been a lesser redacted fees. It could have been a totally unredacted fees. But again, and this is coming from the cases Wanshoff Corp versus OE Paper Box Company, 166 Georgia App 242. And what it says is an allowance for attorney's fees cannot be based on guesswork. If the party seeking attorney's fees may fail to make a proper case for the attorney's fees, they must be stricken from the award. And so I think the particular issue here is the extreme redactions. That does not show any attempt to allocate. It shows we've redacted, we can't say anything. Mr. couldn't remember what specific things were on the stand. And like I said, I understand that this has been going on for a while, but she's the only one who had the opportunity to actually look at the unredacted and be like, oh, this is what this is for, and this is what this is for, which certainly could have refreshed her memory here to illuminate some of these things. But basically, we have redactions, and I don't remember specific itemizations of billings, and that is not making any effort to allocate whatsoever. Basically, they've just said, we can't do it, so we must be an exception. And that's not proper.
Can you give me the last 3 digits of the site? It was 166 Georgia Appeals.
242.
242?
Yes.
All right.
And I will put out here, like I said, and I said at the beginning, I went through this extensively, and I knew that on my side of things, clearly the jury awarded them attorney's fees. And if I could find anything that they were entitled to, my responsibility to say, okay, here you go. I didn't want to come in here and just say, oh no, they get nothing, because that's not particularly fair either. And that's why I went to the links of cross-referencing pleadings, emails, you name it. I mean, it took a really long time. And so with there, and you notice that my exhibit was tabbed up, and it's because I was like, okay, here's where there are things that are clearly related to counterclaims. Any show stack entries absolutely are related to the counterclaim. That's the only reason he was here. The large itemized billing that I asked Ms. Sturm about that went to the gun brandishing video and all of that. I mean, that was all related to the counterclaim. So I calculated every single one of those fees, and the amount that I got to was $2,932. And I realize that's a low amount. However, it's because those could be deciphered, but nothing else could. And I mean, even if I can glean, like if I were to have gleaned from any pleadings or whatever, this is counterclaim based, I would have counted it. But most of the pleadings went to the construction of the easement, which I believe is a defense of the Anderson claims for the reasons we've already discussed. But I think because I was able to find things that actually did relate to the counterclaim, that goes to there was ability to allocate. And I think for the purposes of the trial, and while we're here for the motion for new trial, the big issue is there was no effort made to do so. And that's very different from being an exception.
Got it. Anything else?
No, Your Honor.
All right. Well, I appreciate your preparation for this as well. Mr. Edward, trust me, I was going to turn to you. You have been uncharacteristically quiet throughout the proceedings today. So,
I appreciate that.
well, I don't know who else does, but why don't you add what you want to add, please?
Okay. Thank you. And Kristen did a great job, but she was not involved in the case in the appeal and pre-appeal stuff. So I just want to address that briefly. There are three claims in this case, or were three claims in this case, which are clearly separate and distinct from the nuisance, from the alleged trespass, from the alleged interference. And those claims are, number one, construction of the easement, which has nothing to do with the facts, the acts or omissions, what anybody did to annoy one side or the other. That is a pure issue of law for the court. And with all due respect, we disagreed with you and the Court of Appeals agreed with us. The issue, the competing claims on construction of the easement was exclusive means exclusive. The Andersons can't even set foot on the easement. That would be trespass. And that's where we disagreed, and that was highly, highly, highly litigated. That was our affirmative claim that they defended. And we ultimately prevailed on that. Now, from looking at the statements, as redacted as it is, there are plenty of entries that we can glean are related to the cross motions for summary judgment, the arguments before the special master, motions for summary judgment that we briefed with you. We didn't have oral argument on that, but there's considerable evidence in the record. Look at pages 30 to 32. Page 30, the very top entry is draft, revise, heavily redacted. Review, edit, draft, completely redacted. But if you look at what's going on here by looking at the pleading file, they are working on their response to our motion for summary judgment that we argued before the special master. Same thing if you look at page 33. Review, consider, and evaluate reply brief, blank. Discussions, hearing and preparation. Plan and prepare for hearing. special master blank, special master hearing blank. That's on December 6th, 4.5 hours combined between the two of them. So it is possible, might be difficult and it might take some time, but it is possible to go through these records and compare the record, and particularly when they have the unredacted versions that they have at their office. They can go through the unredacted versions and compare what they really did and what it was related to. But there's plenty of evidence in here showing the briefing and the arguments related to construction of the easement, which has nothing to do with the trespass claim. And frankly, as you may recall, their trespass claim was because Tracy Anderson had the audacity to put some trash in their dumpster. So the easements really didn't have anything to do with the trespass. The other unrelated claims, which are clearly separable, was the claims for abandonment and adverse possession. And again, that's all based on facts which predate either side buying their property. And if you look at page 27 of Exhibit 1, we see about fourth entry down on 10/19/21, Casey Sturm, 3.2 hours, traveled to and from Peachtree Corners, Georgia, blank. Why? Depositions appear, attend, and examine blank. Follow-up communications with counsel blank. Well, you don't have these records, but we do have these records, and I'm sure that Ms. Sturm has these records. What the records show is that the Darbys, and as you may recall, the Darbys are the predecessor entitled to the Davids. The Darbys were deposed in Peachtree Corners at Miss Medwick's office, actually her predecessor, Mr. Jenkins. They were deposed at Mr. Jenkins' office on December 19th. So it's not that it's impossible to go through and separate these, the time they spent on abandonment, adverse possession, construction of the easement. It's that it's annoying and that it will reduce their number. So they have chosen not to do that so that they can make this big argument that everything we did, with the exception of the TPO and the appeal, are inextricably intertwined. Well, that's not based on evidence. That's based upon Ms. Sturm's self-serving testimony. And if you look at the actual documents, you can tell that some of this is unrelated, but it's not our burden to prove to you what is unrelated. It's their burden to prove to you one of two things. Either everything we did was so inextricably intertwined, we can't possibly do any allocation, or that we've tried to do so and we can't. And basically, they're asking you to give them a free pass because based upon these heavily redacted documents, it's impossible for you, Robert McBurney, without additional evidence, to make an informed, educated analysis. Well, it's not your job to fly spec it. It's not our job to fly spec it. It's their job to prove it. And they have access to the unredacted documents. They have access to the pleadings. They have access to the depositions. We have all of these emails on page 26. Call with Randy Edwards, email communications with Randy Edwards, email communication with Randy Edwards. As you may recall, those are the emails that we introduced. You didn't let them go to the jury, but we introduced them into evidence showing this was when the Davids had the landscapers out there cleaning everything up. And this is where we were trying to de-escalate matters and have a timeout and a truce. So Ms. Sturm easily could have pulled those out, but she chose not to. And yeah, these are 0.2 entries and some of them are 2.0 and 2.5, but they add up. They add up. And I don't know what they add up to because it's not my job to do it. But you can't just take their word for it based on a totally redacted document that it's inextricably intertwined. And the fact that I may have dropped the ball and over redacted our invoices doesn't give them a free pass to do the same. I was wrong. I admit it. They're wrong. They need to admit it.
Question, how does, I appreciate you identifying some areas that you think are cleanly separable from the counterclaims. I pulled up the answer with counterclaims and let me check one more thing and then I'll ask my question. So the Davids were successful with counterclaim 1. They prevailed. That's interference with easement rights.
Correct.
How, and you've identified, I think these were the 3. One of them was very clearly construction of easement. You say that's purely a question of law. The second is, I guess, all the litigation with the special master, which related to construction of easement, and then abandonment and adverse possession. That last one, abandonment and adverse possession, I'm agreeing with you. That's who was using the land and in what way, and it doesn't have anything to do with the construction of, I guess it could have something to do with it if it had to do with the meets and bounds, but that was never the fight over the easement of where is it exactly. It was who can do what on it and are you respecting it. But the construction of the easement, in other words, what does it mean and how does it limit me and how does it limit you and how do we coexist? How is that not central to whether one's easement rights were interfered with? Don't you need to know what the David's easement rights are before you can say they were interfered with? In other words, don't you have to construct that easement to say, here is the bundle of rights that the Davids enjoy versus these are the bundle of rights that the Andersons enjoy. And by making that construction, and saying this falls into the David bucket. Oh, look at that. The Andersons messed with that one. That's interference with easement rights. And the jury said that. I mean, they found that your clients interfered and you can say it's just throwing trash in a dumpster or something. But the jury found what it found. In order to do that, they had to construct an easement, which means the lawyers for the Davids had to engage in legal argument about what that easement looks like and what the jurors should, how they should process it and apply it to the facts and evidence that were presented at trial. And so I'm now going to repeat myself and try to consolidate this. Abandonment and adverse possession, it does seem like that is carve-outable, but construction of easement, I don't understand your argument as to how that is so distinct and separate from all the other things that needed to be sorted out by the parties.
There has never, ever, ever in the history of this case or before this case been a dispute as to whether the Davids had the right to make any lawful use of the easements. Period. End of story. That has never been disputed. The dispute over construction of the easement was whether the Andersons also had a right to make lawful uses of the easements because it was exclusive means exclusive. And that's what you said in the summary judgment and the court of
It's not what I said, but you can keep bringing that up. But I'm hearing you. And despite the fact that your clients testified that we were bothered by the way in which they used the easements. You're saying that's what the easements meant. There still was litigation about, argument about, what does the easement really say about then it's what the Andersons can do. And are they able to do this? And if they do this, does that constitute an interference? Or no, legally it can't be an interference because they've got a right to do X. So I guess that's where I'm not connecting. Help me connect.
The grantor or the fee owner subject to an easement. There's never been any dispute that in theory they can interfere with the easement holder's use of the easement. So that's never been disputed. it's been disputed what the Andersons did or did not do that may have done it. But the core dispute was the Andersons can't set foot on the easement and probably shouldn't even look at it because that's using the easement.
Okay.
Exclusive means exclusive. So that was frankly why the case was filed. You know, I don't want to get into what happened before the lawsuit about whether we responded or not. We did. It's in her.
All right, well, you're getting into it and you don't want to get into it, so
Okay,
move on.
Well, I do want to get into it, but I know I
Yeah.
can't. But the issue is simple. The issue was if we had lost on appeal, anything the Andersons did would have automatically been interference with the easement rights. But it's never been argued by us that the Davids cannot make a lawful use of the easements. Now,
So I'm gonna interrupt you because I may now understand your point. Do you believe that the legal debate about the construction of the easement was resolved by the Court of Appeals such that by the time we got to trial, that wasn't an issue anymore because the Court of Appeals said, look, you coexist. And in fact, the grantor of the easement, of course, enjoys usage rights as long as they don't, I can use the right word, compromise the David's right.
Yes. We won that issue subject to, but that doesn't give us carte blanche authority to interfere with their easement rights as recognized by law.
Okay.
Nor does it give them the right to create a nuisance on the easements. Those common law and statutory issues were totally irrelevant to construction of the easement. The only issue for construction of the easement was, do the Andersons have any rights whatsoever to use the easement for any purpose?
Okay, and the Court of Appeals answered that, and so anything we're doing post that doesn't relate to construction of easement. It is a separate issue, and so that's also something that could be carved out, and frankly is a reason to carve out the appellate expenses.
That's exactly right. That needs to be carved out, and we can carve out some based upon the redactions,
right?
But we can't carve out everything, and they've made no attempt to do so, and it's their burden.
No, I got your larger point, and Ms. Medwick made that as well, that there is a burden, and the Andersons' position is that that burden wasn't met. It doesn't look like it was made. Is your position? Given what you've helped me better understand about construction of easement as a category of readily excludable, not intertwined issues, isn't it a bright line in the billings to say, well, it's somewhere in the whenever the Court of Appeals ruled billings that it needs to be pulled out, but post Court of Appeal ruling, there wouldn't be billings related to construction of easement because then it's done. Okay. All right. That was helpful. Anything else from counsel for the Andersons? Nope. All right. Thank you. Mr. Schneider?
Yes.
Do you have 3 minutes or less of, I gotta say this after I heard what these lawyers just said?
I do.
As long as it doesn't have to do with the appeal.
It does not. If they wanted to scrutinize these bills, they could have done that at trial. They didn't cross-examine Ms. Sturm at trial. That was the time for them to make their argument and create their record that we could have seen all of these things, these redactions, we don't understand them. They did not go to the trouble of doing that at all.
What about the observation by both lawyers for the Andersons that they don't have a burden in this space? And so your burden was to make plain to the jury what is allocable and what's not. And they said you get it all. but they were wrong because you can't get it all because you didn't prevail on all of your counterclaims. And so here we are.
Well, we get back to the intertwined rule. That's why the rule exists.
Okay.
You know, I heard her talk about this extreme cross-referencing that she did, but that's not here today. I wasn't at trial, and so it doesn't exist for the purposes of this analysis.
Well, I think she was talking about all the Post-it notes on.
Right, but to the extent that her argument was essentially that, you know, we could have done this, or she was able to retrace all of that, that's not before the court. It wasn't before the jury and shouldn't be considered. In terms of the abandonment and that was a pivot when they were trying to get us off of the easement area entirely. Hey, no, that doesn't even exist. Your rights don't exist. It was an argument they carried to the end. So it's not as if the rules were set by the easement determination, and thus I've breached your request. Yeah, those are the key points for me.
Okay.
I think, you know, the easement remained to the time of verdict the underlying arbiter of what the parties' rights were. You can't dissect that out. It's the spine of this case. I'll end it on that.
I like that, the spine of the
metaphor.
case. Okay. Well, counsel, it was a nice reunion. I apologize again, in particular for this afternoon. I had much less control over this morning, and we triage in this job, and murder comes before easement rights. This afternoon, I just got stuck somewhere and said, I need to go, and I was finally released, but it was not a real efficient use of your time, and for that, I apologize. I will take all this under advisement and get something out, and then you guys will take it from there. Anything else on behalf of the Andersons before we wrap up?
No, Your Honor.
Okay. Anything else on behalf of the Davids? I don't know who arranged for Mr. Bobadilla to be here, but please make sure he's taken care of. I will leave it at that. Everyone have a good Friday.
Thank you. You too.
Bye-bye.
Roll Tide, everybody.
Roll Tide. Tide and Seahawks.
Hey, your Niners are looking good.
They are. Well, their record is looking good. I don't know how they have that record. They're defying expectations with a one-legged Mac Jones winning games.
With an Alabama quarterback, exactly right.
I knew it, of course. There's the DNA. Good. All right. Well, you should sign off before you say more about Alabama. You guys take care.
Thank you.
Your Honor, is it okay if I check in with the court reporter to see if he needs anything from me?
Yeah, sure. So we'll go off the record so he can talk now.
Beautiful. Thank you. Ms. Medwick, would you be ordering the transcript?
Yes, sir.
And would you like expedited or just standard?
I think just regular time is fine.
All right. And then passing it off to yes, please don't leave without the links. Right, thank you. For Mr. Snyder, would you be ordering the transcripts as well? Sure. All right, it would e-transcript be okay? Yeah, that's fine. And standard? Yeah, standard. All right. I have no other further questions for you, Ms. Medwick, or Mr.